Did you need to do a mic check?
We've got some issues.
We'll adjust as you go.
Business to clean up, so I'm going to go ahead with
They
that.
don't seem to be on.
Oh, it doesn't identify the room, that's for our purposes.
Okay.
I don't know what Dawn wants to do, but
This is the agenda, the last agenda I got, I was at this thing with all these on it.
John, I asked 4 times for the agenda and I never got it. So just deal, this is what we have.
These applications, I already heard them. Well, he hadn't listened to the public.
Yeah, but we have to do these applications because there were errors made.
Because they forgot
and
to
they
put
need
them
be
on.
cleaned up. And we're waiting on some people
Oh, that's
anyway.
the part I
Town
need to know.
council's not here yet, so why don't we just go ahead and hear this business while we're waiting?
Okay.
Okay, I'd like to call the December 6th HDC meeting to order. We are recording and taping the meeting. If anyone else wishes to do so, they need to let me know. And we will, are there any public comments?
Probably missing ones. No, I know.
Hearing none, we'll go to consent. Does anyone have any questions? Do I have a motion?
I'll make a motion to, oh, I can't sit on 1 and I can't sit on 2.
motion to
Okay.
approve.
Linda's recusing. All
From one
those in
and- yeah.
favor?
Aye.
Aye.
Any opposed? Any abstentions? John, you good? Okay. That's 4 in favor. Old business. Number 1 was actually heard on Tuesday, so we'll strike that. Number 2, Jim Murray, 23 Bank Street. Do they know that this is on the agenda?
Anybody tell them?
Luke and Carrie?
They just wanted it to come to the meeting, but I don't know.
James, were
I
these
don't know.
supposed to be on Tuesday night also?
These are from the previous meeting. They've been bouncing along outside of the normal schedule, which is why they were not on the meeting of the night.
Or were they told that they were coming up tonight?
They were told they were coming up the next full business meeting, is what I understood.
Well, then they have no clue that it's coming up
I
tonight.
think that maybe a motion to hold these till the beginning of Tuesday would be in order.
I'll make that
Because I think they
motion.
need to be here.
I'll make the motion to put 2, 3, and 4, Jim Murray, 23 Bank Street, Sconset. The 3 applications, the very beginning of the next meeting.
All those in favor of that motion?
Aye.
Any opposed? Motion carries unanimously. Jeannie Garofalo, 4 Monomoy Road. Do they know that this is up?
Well, I think one of them was going to be here anyway.
I represent that client, I think we'd like to continue to next Tuesday.
I'll make a motion to put Jeannie Garofalo, 4 Monomoy Road, to the beginning of next week's business.
All those in favor?
Aye.
Any opposed? Motion carries unanimously.
Well, there wasn't any reason to go that fast. Town council will be here shortly.
Is there anything else that we can move to without?
I think there's probably some things you could probably entertain if we
I don't
wanted.
think we should.
I don't know if, start with
50
C. You
Union
could-
Street people here?
Question, have you done the public comment section, or did you just give?
I did that at the beginning. We would like to hear a public comment at this time, since we're holding for town council.
Sure, I have a public comment. My name is Stephen Cohen. I'm an attorney, as you know, I practice before the board all the time, sometimes representing applicants, sometimes opposing other people's applications. Last week in the newspaper, one of the commissioners wrote a letter that criticized me for seeking to have the Board of Selectmen examine the HDC, and also criticizing me for representing a client before the HDC where that commissioner does not like the application. I find that to be entirely inappropriate, although somewhat consistent with the level of inappropriateness often found at the HDC and the level of intimidation that is often put upon people who practice before the HDC. I think criticizing someone for doing their job by seeking redress from the government and by appearing before a governmental board representing a client is inappropriate and elected officials should not be publicly criticizing people for those actions.
Thank you.
Can I ask if any others?
Does anyone else have public comments that they'd like to make at this time?
Should we call them and find out where they are?
Well, I think we need town council for part of that. Yeah,
For which one?
just a minute. We talked about it briefly, just, I think it's helpful.
I thought we were having
What?
cost management here today.
We are
They will be.
supposed to.
They, just, Madam Chair, town council and plus management, i.e. Andrew Vorse and Leslie Snell, asked about how long it would be. And I said it wouldn't be at 5. Obviously, we had a few old business items and new business items to take care of. So they're anticipating that that'll take a little bit of time. I said sometime around 5:30, I would think that we would entertain the rest of the agenda.
Well,
So
That's incorrect. But
it's only 5:08, so
Dawn,
can we move ahead with 50 Union Street?
we can do 50 Union Street, we can do Leiden's roof proposal.
yeah, I think there's
Is Jim
items
live?
below there.
The problem is I'm not seeing people here. I see Robert.
Robert's here.
Robert, are you ready to present for 50 Union Street? I have to recuse from this,
Okay, you want me to chair?
so I think it's appropriate for the board to just elect who's going to chair.
Make a motion to elect Lynn to chair this item.
Okay.
All those in favor?
Aye.
Any opposed?
Okay. Robert, step forward, please. We're going to hear 50 Union Street, a preliminary review. I believe we have a handout.
Can I sit here?
Yeah.
Yeah.
Yeah, I emailed everyone for the last, I think, 3 meetings were
Hold on.
postponed.
Here comes the handout.
This is the first time that members have seen it, the handout.
Most of them, yeah.
Madam Chair, the members were emailed this information or is posted on the web, so
Yeah.
they've had an opportunity to see this.
Look at the web.
There are extra copies here if anybody would like to see them.
Let the record reflect that Dawn Hill Holgate has recused from the discussion on this matter. Okay. Do you want to set us up?
I'm hoping, as my cover letter presents, that the house on the corner of 50 Union Street, which is currently a duplex, it's 2 apartments, that...
Hang on one second. For a sound check, do you need a microphone for the applicants? Okay, right there.
I'm hoping that all the different boards of this community can work together with me in allowing the move of 50 Union Street, which is currently a duplex on the corner, precarious corner of Union Street and Francis Street. I think everyone in the community will benefit if the HDC will allow this move. There's a variety of reasons why it's a great idea. I think anyone who drives into town in the summer knows it's certainly a traffic concern. It's a very tight turn. In the presentation that I emailed you, there are several pictures showing, trucks and semi-tractor trailers on the wrong side of the road because they can't take the turn. Cars backed up, 18-wheelers backing up to try to take the turn. The house, the reason why Dawn Holgate recused herself was because Housing Nantucket is willing to move the house onto they've looked at it already. Their board has voted the approval to move it on Miller's Lane near the airport, where it can be used for affordable housing. The town of Nantucket has already worked with me in developing a road plan where they can improve that corner. The land bank is already on board and has made a financial commitment to taking over a percentage of this property, and we've talked about doing a pocket park, such as the one on the corner of Main Street and Fair Street. I think this one, you're also opening up vistas to the water, which the land bank liked as well. So there's just, the greater good for the community if we can move this and use it in a location where it can be for affordable housing and make better sidewalks and traffic flow. So with that, if there's any questions, I think everyone's very familiar with this location. The house has been added on to many times over the years. I've included, all the information I found on town record. It was built, we think, sometime in the mid-1920s, and then added on to and became a duplex probably in the 80s. So, yeah.
Okay. Let me see if the board has any questions at the moment. Kevin?
But also, can I make one other note? We did bring this, I did a citizens warrant that was passed 2 years ago at town meeting. That's in the cover letter as well, where it got unanimous support that we allowed, if this is allowed to be moved, that the selectmen would have the ability to transfer this property.
Just to clarify, the property at the moment is in private ownership, right?
Correct.
Okay. All right, Kevin?
I have looked at this while I like our narrow streets. I think this is a problem that everybody would benefit from having this opened up a bit more. So I have no concerns with it.
You have no concerns about moving it out to Old South Road? Okay. John?
My theory, better to move it than tear it down.
Okay.
I have no concerns.
I have no concerns either, so that's the 4 sitting members.
Okay.
You haven't brought a formal application back to us again, but I
No.
guess you wanted a sense of the board before you went through that process.
Yes, I've been patient with all the different boards. It's been 2 years in the works to try to get it to this point, and I was told that this would be the best first step with HTC. So now, is it safe to say if we did put in an application for a move, we're not going to have to jump through hoops?
Well,
Madam Chair.
we can't commit to a vote on a preliminary review, but you've heard sort of the sense of the board
Sense.
and that there's a lack of concern. So obviously, it has to come through the regular permit process
Right.
of moving it off and then moving it on to Old South Road.
And
Village
what
Way.
would, if the application was submitted, say, next week, what would the turnaround time for an up or down approval be?
Well, that you'll have to talk to the staff about that one.
Okay.
It depends on when you submit to us. I mean, we have our deadlines listed in their schedules and everything, so. But I did want to make sure that as a preliminary review, you haven't heard any other comments.
Right.
And the board should just only ask questions about anything that they'd like more information on. And you would have to be duly notified to any abutters, and any other interested parties would then pick up the agenda when it's submitted to our office.
Right, because there's going to have to be a public notice to move it off and public notice to move it on. It's over 1,000 square feet. It's also coming out of the old historic district and going to a location not in the old historic
Right.
district. But I think you wanted to know if it was a viable,
Yes. and is there any
project.
concerns on this board?
anybody have any
I
concerns
mean,
about where
I
it's
thought it
going?
would be pretty straightforward as myself. but-
Not on what I have in front of me.
No questions?
Do you want to ask if the audience has any? I don't know if they called it.
Are there any comments or concerns from the audience about moving 50 Union Street on the corner of Francis and Union to a location out on Old South Road? Identify yourself for the record. Do we have a microphone for the public, or do they have to come up?
That's okay.
You're welcome to get it back.
Valerie Norton. I would be concerned, it's, the house has been there since 1924. In my mind, that it's been in that location, it has a place. Our roads have gotten wider because of need, but I still think that it is a maneuverable corner with the house presently there.
Please
We're-
look at
I got
All right,
everything.
keep conversation between the two of you to a minimum.
Possibly what I would suggest is removing a piece of the back addition and moving it back and leaving the presence in its spot.
Okay, thank you for your comments. Anybody else has a comment about the move? Andrew, Leslie?
It probably, I have one more comment.
Okay. Any further comments from the board?
It probably would be good as part of the application to get, some as-built elevations, so the application would be complete.
where it's going, you mean?
No, just what so that we can see where the additions are and what's built there now.
Well, they've done a road improvement. The town has already spent the money to do that, and it's beyond the addition to get that radius. This is part of the packet of what Leo Asadorian did in Blackwell's office to widen that turn, and even, you'd have to literally move the building.
Well, I think we have all four.
If
We have all
you
four.
can't just remove like part of it. It's not even close for them to do a proper turn. It's more than a few feet.
I think what Kevin was referencing is making sure we have full photo documentation of the structure, where it's sitting right now in the
Sure.
file. Is that what you're asking? Color documentation? I think all four sides are visible. But when you come in, just make sure you have the photos.
Okay.
Is that what you were asking?
Well, I just want to I would like to be able to explore Valerie's notion, and I'm not sure that there's adequate drawings to do that.
It may be a good idea then for the board to do an on-site visit and have exactly that's what the Housing Nantucket did to see the house. And I would suggest, it's easy to say, oh, just take part of it off, but it's not going to work. We know that. I mean, there's been thousands of dollars put into this plan by the town already, showing what needs to be done if we're ever going to improve that corner.
I think what might be helpful when you do come back is to, if you can, over the aerials, because there's 1938 aerials that shows this house, and then there's a 57, and there's a 74, is to see if you can date which pieces were added on at what time period. I don't know if the Sanborn maps are going to help you completely, because it doesn't look like it. But Devin wants to know what's where on the structure.
Sure, I can.
So as much documentation as you can submit when you come back, the better off. And when it comes back, we'll probably make a motion to go to a view, so the board will have an opportunity to take the information that you give us and then go to a view.
Okay.
I think I could help you with that a little bit. There are standards on looking at the progression of the structure over time. And I think that's what he was talking about. Correct me if I'm wrong. Did you look at the original part of the building as much as you can in any later additions, so you graphically show that so that there's a better understanding of that structure? But
Okay.
Okay.
call me if you know what to do.
Any further comments? Thank you very much.
Okay, you're welcome.
Kevin, you want to make a motion to close the preliminary review?
Make a motion to close the preliminary review on 50 Union Street.
Any further discussion? All those in favor?
Aye.
Aye. Thank you very much.
Thank you for your time.
I see that town council and various other town officials have arrived. Would you like us to segue? Is there a time constraint on town council going back out? What time?
We were hoping to catch the 8:10 fast ferry.
If we're still here at 8:10, we got bigger problems than I think we do.
Excellent.
I'll turn it back over to Madam Chairman. We're down to town council now.
Okay, so we'll just go, we've already heard consent, old business, new business, and we skipped down and heard 50 Union Street. So now we're going back and starting with number 1, town council opinions on a stop work order issued September 4th, 2012. Yes, please.
You guys want all these handouts, or anybody who doesn't have them, just
I
let
think
me
you
know.
need to hand them out.
Around so we have them in front of us.
And there's your microphone right there. When she gets back. I thought she was, or she was still at work. You have to identify yourself.
Good evening, I'm George Pucci from Town Council's Office, Copeland and Page.
And you, just for anybody who doesn't know, you're the town council for the town of Nantucket.
Yeah, Copeland and Page is Town Council for the town and county of Nantucket, and I'm here on behalf of Town Council's Office to go over some of our Town Council opinions and any other questions that you may have.
Go for it.
Okay. Well, I don't know the nature of any questions that you may have. There were a series of town council opinions which have come out over the last few months. You've listed a number of them on your agenda for tonight. We can go through them in order. I don't know if you want an overview of what they say, or you just want to ask specific questions with regard to what's in some of those opinions. It's really, whatever your pleasure is, I'm happy to.
I think an overview would be appropriate because
I do have questions.
the audience and
Can the audience hear everything that we're saying up here? Because we don't have a microphone that actually amplifies for the room. We have a microphone that amplifies over there.
Yeah, do you want me to?
Yeah, that might be
we'll
good.
try.
And there's a
Some
microphone
people
right here.
could move closer.
Y'all can move in. You sit a lot closer
Sorry,
to
right
us in the
here. Okay,
normal
well,
hearing.
I'll try to speak up.
Don, when the public goes to speak, could it come down to the microphone?
Yes.
Yeah, I can't hear.
Well, the microphone doesn't amplify, John, but they can come to the table.
I can hear. Okay.
I see, so this microphone doesn't amplify for the folks in the
No,
audience.
it's
No,
strictly
it's
for
for the television.
the
And
television.
I'll raise my voice as much, without making it too abrasive, but can everybody hear me in the back? Okay, all right, great.
Hold it.
Just to let you know, everybody on the table gets picked up by the mics really well, so you don't really have to speak into them like really closely. Picks up everybody.
Okay, but it's not helping the
Not helping
audience for
them.
any amplification.
That won't happen.
Okay.
If I'm going to be raising my voice, then I'll put the microphone away because that will be an unpleasant
we should all push them
television
away a
viewing
little bit.
experience. So anyway, what I just said was, over the last course of the last few months, there have been a number of town council opinions on various issues that have come before the commission. Those opinions are a matter of public record. They've been identified on the agenda. And I'm here to either review those with you or answer any questions that you may have concerning them.
I have a couple of questions. If we have not been posting meetings correctly since July of 2010,
Yeah, Linda, I
would it
think we
make
should
sense?
go in order.
You want to go in order? I just don't have any questions about that.
I have a question.
I do have a question about that one, actually.
Can we start in order?
Okay. The stop work order versus cease and desist. The HDC has the right, through you, to issue which one? Because the language, unfortunately, has been used interchangeably for the last 4 months.
Just to have a recap of the issue, the administrator was using, at one point in time, the building inspector's stop work order form, which is a red stop work order, basically a template of art that applies to the jurisdiction of the building inspector. And what we recommended that the administrator do is not to use that form, because that raises certain jurisdictional issues. But we did suggest, if you want to put something in writing to the property owner or to a contractor or somebody doing work, that you want to get their attention, we crafted a template that the administrator could use for that purpose. And the template is attached to my letter about enforcement options that you have. And the way I drafted that template is so that it's as usable as possible, that you can plug it into whatever situation may arise. Now, keep in mind, that's a way of getting the attention of the person who's committing the violation. It has no effect in itself. I mean, the person doing the violation can choose to ignore that, in which case, you're going to have to take more formal enforcement action. But it is a good way of getting the attention of that violator. It also sets up a record if you do end up having to take enforcement. You can document a nice record of attempted voluntary compliance, and it makes you look more reasonable, especially if you have to end up being in court on a violation, that you did everything within your power to try to get voluntary compliance, and then you were forced to go into court finally. It also saves the potential expense. If you can get somebody's attention without filing a court action, it saves a good amount of money for the town.
what is it called as opposed to a stop work order? We're calling it a cease and desist.
Yes, the template that I provided, you could put any label on the top of it.
Okay.
The only reason for the distinction with the stop work order is the stop work order is a distinct instrument that is issued under specific code provisions for the building inspector to use. So, you could say stop work or cease and desist.
Because this is all filled in from the one that shouldn't have been issued.
Correct. That's
Okay, so
the
this is the
stop
way
work
it
order
should
that
be
you should
done.
not be using.
Right, where's the new one?
Where's the new one?
Is attached to the letter that you have with,
Oh, is this the? No.
No.
It's not.
just bear with me one moment. The enforcement guidance letter dated October 26, 2012.
Hold on. It's facing backwards. No,
It's the one.
it's this
smaller
letter,
notice.
basically. It's this document.
Yes, it's attached as an attachment to that October 26 opinion letter.
Yeah, and you called it a notice of cease and desist, which makes it separate from a stop work order. That was
Correct.
my concern, is that those words were going back and forth, and they cannot be used that way.
Yeah,
Stop work order is a building department jurisdiction
Right.
only.
Right. And as you see, do all the members have it now? The cease and desist that we crafted it's easy to just plug into the particular situation. And what I tried to spell out for you in there is the things that you want to point out to the person committing the violation, and then asking them to come in, and then you're reminding them of what your more formal enforcement authority, including your fining authority, is in that letter.
When do fines start being accrued?
Then-
Only after a court action?
No, you could also follow the ticketing procedure that we describe, how to follow that in that October 26th letter. That's spelled out in there. I had said this before, it's not a model of draftsmanship the way there's sort of a patchwork of regulations that apply to the commission. So it becomes somewhat mind-numbing if you're going to follow exactly the procedure that you need to follow. That mind-numbing procedure is spelled out in the October 26th letter in terms of how you do a ticketing procedure, or how you go in for a non-criminal disposition, or if you do a fine, and then ultimately you have to enforce all of this stuff in court if they don't pay it, so.
That's what I'm saying, you can assess the fine, they can decide not to pay it, and that's part of the court enforcement, which is done through you.
Yes.
Only.
Yes. Well, the ticketing procedure you can do without counsel, but it's a cumbersome procedure. Not the place that you want to be.
Right.
Criminal courts are not the greatest place for land use permitting issues.
Okay. Does anybody have other questions?
I have a question regarding the second page of your
Madam
handout
Chairman, are
here.
you taking public questions during?
Yes, we will.
Okay, so I have a few questions about each of these, and I'd just like to go as the board goes through.
Okay.
Uh,
I thought I was
He's
speaking.
speaking right now.
Right, but he wanted to move on. Could I stick on the one?
No, no.
Oh, okay, I'm sorry.
We'll stay.
But just let me know, if anyone wants to speak, please let me know and I'll recognize you, and I'd like you to come up to the table so people can hear you.
Kevin, you're still on A and B or whatever? it
Yes,
is?
and this is the cease and desist for 108 Cliff. I'd like a little bit more explanation as to how word came down to the commission 2 minutes before the meeting that was supposed to be resolved that night. Perhaps you can...
Thursday, it was a Thursday day.
It was a day meeting, I guess, yeah. Maybe you can, we've asked to get some explanation on that and haven't heard a word, so I'm just curious as to how that all happened.
I'm not sure what does this relate to the, I'm not sure what the...
This relates
what
to 108 Cliff and the cease and desist order, and the, basically, as I understand it, the instruction was from town council to settle the matter.
108 Cliff isn't on your...
It's your second page, right here.
Well, unfortunately, it's the example on the second page of your packet. It's the example.
It's the cease
It's the one
and
that
desist
should have
order
been-
that
this one.
was issued that was not the right procedure.
ERS.
Oh, yeah, no, that's not my packet, though. That's
That's
in
our
fact, that's
packet.
not, yeah.
And this
That's
is
not
what
on
should
your
not have been
agenda.
issued. correct?
Yes, that should not have been issued.
I think Kevin's question
does
was,
that-
Madam Chairman, if I can,
No,
because I was
no.
there. Well, I think Kevin's question was, is that when we met that Thursday, there were only 4 of us there, and word had come to us, well, actually hadn't come to us until after the meeting, but had been relayed to 2 individuals before the meeting, that you would like us, at that point, to make a decision on whether it could be demolished or not demolished, or, but do it at that meeting.
Right. bring it
And
to
you
a
had
vote.
spoken to, I believe, staff and the chairman at the time, and none of that was relayed to the rest of the board until after the meeting. Yet we went ahead and made a decision that day anyway, but none of us were in possession of the fact that you had asked that we do make a decision that day.
Oh, I
And
think
he wants to know how that happened.
I think I recall that now. That was the one where there were the charges of an open meeting law violation.
Right. Trespass.
And trespass and due process claims. That issue did concern me, as you know. I was in a meeting in person where the applicant and town moderator who represents that applicant had made some charges about due process violations. We came in and tried to give a course of action to follow, and then what happened was I received an email from counsel for that property owner the night before your continued hearing, raising an issue as to whether they were going to be heard or that you weren't going to be able to resolve it. So I don't deal directly with your administrator. I deal with the Director of Planning and Land Use Services, and we spoke at about 10 or 11 a.m., and I said, you know, I don't have an opinion one way or another substantively how the commission should rule, but the commission should definitely not try to continue this matter any further. They should try to reach it substantively at the hearing. And how that gets relayed then to the commission is not really, you know, something that I should be involved in. So
But it didn't
if you ended up getting word
We didn't.
right before the meeting,
Until after the meeting.
yeah. But I would have assumed it had, you know, my advice had come through, and it wasn't the type of thing that really was to be concerned about on my part. I just received an email from the applicant's counsel, and I relayed over a telephone conversation, you know, please make sure it gets addressed tonight, you know, at the meeting, so.
I think that Andrew Vorse would like to address that question.
Thank you, Madam Chair. I just want to second what George had said. He asked me to convey, which I did to staff member Breeder, to make sure that the commission came to a decision. What didn't say what the decision would be, but not to keep continuing the matter. So the point was to determine whether a demolition had or had not occurred. And that was the instructions. I believe he conveyed that to your chairman. And then I don't know what happened after that.
Thank you.
Does that answer your question? I'm going to go to Stephen Cohen.
Sure, thank you, Madam Chairwoman. What's going on here is very important, and I think should be really appreciated, but it's probably not apparent or understandable to the people in the audience or the people at home who aren't familiar with the case, who haven't read the town council opinion, and who don't know the difference between a stop work order and a cease and desist order. And I'd like to try and put it in what I hope is simple terms, and hopefully town council will confirm. What essentially happened here is that the HDC administrator created a form that was then used to stop and shut down construction sites, and that form is not, there's no legal basis for that form, and that what the HDC does have the authority to do, or is being advised that it has the authority to do, is issue cease and desist notices. And the substantial difference between that is a cease and desist notice says, we think you may have violated the HDC certificate of appropriateness, and we would like to discuss this with you. Please come see us about fixing it. And that is significantly different than the building commissioner's power to issue a stop work order and shut down a construction site. And so a cease and desist is just an allegation, and a stop work order shuts down the building site until the issue is resolved. And that is a significant difference that I think the people at home and people in the community should be aware of, and I hope that town council will confirm that I've said that correctly.
Go through you.
Don?
Yeah, I've told you what my opinion is on it, so.
Thank you.
Mark Foy.
Since I'm being referred to here, I think we need to clarify a few things as well that I don't think are completely accurate. I did not create a form. I used a form that was given to me by the previous building official for that purpose. We had discussed it at length. He was okay with me doing that as long as it was in consultation with him. His opinion was that it was an HTC matter, but it affected the building permit. So that's the process that we had used. I've discussed this with the Director of Planning, and we've talked about that. This is a better way to do it now with more information from Town Council. I'm happy to do that. I never really liked doing stop work order in the first place, but that's the tool that we used. The notice of building code violation order for ERF LLC, which is in your packet here, was issued after I requested that the building official issue this cease and desist order after this board had asked me to do the same. Just so you know, so that's a bona fide cease and desist order, whether it's potentially legal to do that in that respect. That's up to Town Council to advise us as well. This current building official, when I asked him about whether it should be a stop work order or a cease and desist order, which has been about quite a bit of debate, he says it's a distinction without a difference in his mind, because he's used both of them interchangeably, and the forms will substantiate that. Just to clear the record.
I think the difference is our staff has no right to issue a stop work order, period. We can do a cease and desist. So whether or not the building commissioner thinks that they're interchangeable in the pursuit of his job is immaterial. The fact is, we cannot issue a stop work order or take one of his stop work orders, cross it off, and put HDC on it. We can do cease and desist under your guidance, using your form.
Which
So I'm much more comfortable with
I think
that.
has been made clear at this point. I think that staff is clear. I think that the board is clear. I think that we've had the proper advice. And
I'm not clear on something.
James Greer.
When a project, James Greer, working at HTC, when a project goes outside of the design guidelines of the HTC, and that has to come back to the board, timing is an issue for the applicant. When there's destruction of historic property that's going on, and it's time sensitive, and that can never be brought back, what do you do in that situation? If a cease and desist is just going to say, well, we think you're not doing this, you can't ever get that back again. So how do you handle that? Do you then go to the building department and then say, would you please issue a stop work order in that situation?
No, you could, or you could use the cease and desist. You don't have to say, I maybe believe you're violating it. That's what I'm saying. I drafted the cease and desist for you to use to plug in as appropriate. If it's a clear violation, you're facing a demolition, you put that right in the cease and desist and go and serve it. You know, one thing to not get confused about is when we're talking about stop work order versus a cease and desist, we were talking about the red form that says stop work order with citations to the state building code and things like this on that form. You can call your own cease and desist letter a stop work order. You could call it anything. You could call it notice of violation, notice to stop doing what you're doing, whatever it is.
And is the property owner required to stop at that point?
The property owner isn't required to stop in response to the stop work order. I mean, you can only, you're dealing, whoever you're dealing with is going to choose to comply, regardless with that order. What your main thing to do is, if you're facing a situation where you're facing imminent, harm that isn't going to be remediated as a result of any relief that you get, then you want to take some action. You want to go talk to the property owner. You don't want to traipse onto the property, but if you can communicate from the public way, if you can get them on the telephone, get a request for legal services through the Director of Planning to get approved right away by Town Manager, get council involved right away to do something to stop the violation. The main thing you want to do there is stop any type of destruction which then can't be repaired. But I mean, keep in mind, they're all pieces of paper. The stop work order is red colored, yours is white colored, but if they're not going to choose to comply with it, they're not going to.
I'm specifically addressing Mr. Cohen's distinction between those two things. Are they required to stop what they're doing? Does it have the same legal standing and legal enforcement power?
either way, you're going to end up having to get injunctive relief.
Yeah.
That's the problem. If you've got somebody bent on knocking something down, stop work order or a cease and desist letter, a polite or a nasty enforcement
But it
effort, they're still going to knock it down.
It helps down the road.
Absolutely, and I would think most of the
It
time,
doesn't save a building necessarily.
Well, hold on a second.
I would think that 99.9% of the time it
in
would
most
save the
cases.
building.
You also gave us an option, you or one of your other colleagues gave us an option some time ago about if we get into that type of situation, we go to Andrew and Libby to get immediate access to you, and we were told that you guys can go file injunctive relief. And that
Absolutely.
would stop it immediately.
You can go in ex parte, which
Right.
means without notice to the other side, you go to court.
Right.
Present to the court what's going on, you get a temporary restraining order. That can be served that day,
Right.
and it can stop it. And then they are obligated to come in and show cause why that temporary restraining order should be lifted.
But it requires us to have, open communication with you
Yes.
and with Andrew, with Libby.
Yes.
To get that immediate access, because we do have imminent destruction
Right.
of an historic structure.
And if
So
your
it works.
agent or administrator is concerned too about timing, you could raise the issue and then get what you did, your action ratified by the commission at the next scheduled meeting. In other words, if you're dealing with an emergency situation, you have to deal with that on an emergency basis. My first advice would be to go right to your director, get the request for legal services in, and start doing your thing in terms of stopping the imminent harm. Then later, it's an emergency situation, so you're entitled to do that, and then bring it back to the commission to ratify or formulate what the formal action is going to be.
Well, does the commission, that was something that came up, does the commission have to ratify every time he issues a cease and desist? Or can he do it on his own?
I don't see anything in your I don't have the administrator's job description, but I haven't seen anything that would give him the authority to take acts on behalf of the commission without a
Without a
commission
vote.
vote.
So we have to vote on cease and desist?
I would recommend that unless you know about some
That's what we
provision
always
that.
did in the
you know,
past.
Can I just ask him one question before I go to you? So if something was happening, do we have to convene a meeting to vote on it?
Well,
We just
that's,
said we could ratify it afterwards.
it's an
Okay.
emergency, right? You could ratify it at a regular meeting or call an emergency meeting. But typically, you would have your agent dealing with it, and then at your next scheduled meeting, you ratify what he did.
Okay.
So what if they don't ratify what I did, which is the case that could happen, and it seems to be confusing to the opinion that says the commission or its administrator may demand that a property owner cease and desist? Is that only after they've voted on it?
No, I mean, confer with your chair, you have to deal with this on a practical level. You're talking about, I would recommend against taking enforcement action that isn't discussed with a quorum of the board at a publicly noticed meeting. But if you're dealing with a situation, again, of the threat of imminent harm, you've got to confer with your chair and take some action about it, confer with town council, through the director of Plus.
Just to be clear, those things were done. The chair was knowledgeable of this action. Also, what hasn't been spoken about, I was never consulted with the initial consultation with the owner's attorney and the owner himself. I had contacted his representative. His representative had submitted an application already scheduled for the next available meeting. When I went to the site, I asked if it was okay if I could be there, and I asked if it was okay if I could look inside. And I was granted both of those requests.
Yeah, 108 Cliff Road, that's what we're still talking about. It's done. It's fixed. And
it was not an emergency.
But the fact is there were certain things that were done. You got advice. We met with you. That was why, when it was on the continued date, it was my concern that you do reach some type of substantive determination on it. But the issue is resolved. And there's
That we're clear.
all's well that ends well on that. And then what we're talking about now is just advice and specific guidance going forward.
Matt, did you have a question about this or a comment? And then I'd like to move on to the next.
Sure. Matthew McKecker. So I think what's more relevant about this point in particular is about jurisdiction. and whether or not, I think in both, in that particular case, and I was involved in a certain situation as well, where you're doing a renovation or an addition, and throughout the renovation and addition, the contractor basically and/or architect make the decision that, the existing structure is not sound and things need to be replaced. And I think that the way the current charter reads is that the board does not have jurisdiction over the interior structure.
I think that's up next, Matt. We're not there
I think
yet.
that's really at the heart of the issue, and I don't think that, it's if somebody's trying to demolish the interior of a structure or demolish an entire structure, obviously that's not something anyone's looking to endorse. But very often we're confronted with situations that we have to solve structurally, and I think the general understanding in the way that the existing charter reads is that you do not have jurisdiction over that. And so that's where I think a lot of those issues come into play. So I guess that's kind of a question I would have. If we're going to get to that, I think that would be relevant.
Does anybody have any further questions from the board on the cease and desist? Okay. I guess we're moving to inspections, jurisdictional limits, and access.
Just a good segue from what was just said.
Exactly.
It's very clear, your jurisdiction is over appropriateness of exterior architectural features, and then it gives a number of considerations that you have to do that. It also specifically says in your enabling legislation, the Historic District Commission shall not consider interior arrangement or building features not subject to public view. So it's very clear. In terms of inspections, you have to be careful about property owners' due process rights, which includes their ability to not have someone on their property without just cause to be there, or some type of jurisdictional statutory basis to be there. You can't treat them differently than other people, which I have never seen you do that, so far. You have no right to be on a property without the property owner's consent. You can make inspections of a property from the areas within your jurisdiction, and that goes to exterior architectural features from a public way, from the beach, from the ocean, whatever it may be. So you're entitled to do inspections. You're entitled to stand on the public way with binoculars if you choose to, but you're not entitled to go on to a property without the property owner's permission. You're not entitled, unless there's some compelling reason that it would affect exterior architectural features, to be concerned in any way about what's going on the interior of the premises.
Here's the problem with that strict interpretation of it. The HDC approves 4 sides of a building, or in some cases 20 sides to a building. And in order for the staff to ensure that the building on all 4 sides has been built in accordance with what was approved, you have to look at all 4 sides. And sometimes all 4 sides are not readily available from a miscellaneous dirt road. And you have to go on the property with your properly badged to look at all 4 sides to make sure that the whole structure is built in accordance. We're not just approving one side of a structure. Let's stay away from the interior supports for a second. I'm just talking about how is he supposed to inspect unless he looks at all 4 sides, because the HDC stamped all 4 sides. So they have to comply on all 4 sides, whether or not you can see it from driving by on a dirt road or not.
Yeah, if you have jurisdiction over exterior architectural features, so I don't know, it has to go to what the application is and what you approve then in the certificate of appropriateness, what you can
Then you've got
inspect.
to go on the property to do a walk around. That's the point.
James Grader's next. He had his hand up first.
That's the dichotomy for me. You're saying you should only do it from the traveled public way or whatever.
Yeah, I don't.
But you have to look at all 4 sides, which means he has to enter the property and either take a picture and bring it back and put it in the computer, or take the plan to see if they've complied in order for him to sign off on it.
I'd have to look at a specific situation, but I don't see.
It's every situation.
I don't see how you have, there's an application for approval of an alteration of exterior architectural features. So if it's relevant somehow to what's visible of exterior architectural features from the areas that you're entitled to view from, then you can. But I don't see how the Historic District Commission would have to see the back of a building that you can't see from,
Except that we approved the back and it was stamped.
yeah. It's a matter really that,
So we're only going to approve one side of a
People want to
building.
speak.
yeah.
We're only going to
I'm
approve
going
one
to go
side
in
of a
order
building
of who had
then.
their hands up first.
Well, you're approving our exterior architectural features and then,
For just the front of the building,
yeah, I mean, what's, yeah.
travel way.
That's the difference of how the chart is written.
Okay, okay.
James?
James had his hand up first.
The question that I have is about what exactly, when you're talking about a wall, what that means. An exterior wall of a building, which the HDC would have jurisdiction over the appearance of, presumably. Does that jurisdiction end at the shingle that is on the wall? Or does it go through?
Yes.
So the HDC really only has jurisdiction over shingling and some windows?
Depending on what the, you have jurisdiction over building materials, and it depends on what the building material is, but again, it's limited to exterior architectural features. Building materials as relevant to exterior architectural features. If it's vinyl siding, you have jurisdiction over that, you know, but you don't need to see the inside of the vinyl siding to say that's vinyl siding, and we don't allow that.
You understand that changes us from a historic preservation to just design review?
Yes, you're not a
I'm
historic
coming to
preservation
you.
commission.
I'm coming
Can
to
you
you.
repeat that?
Okay, go ahead, Bob.
Here, Mr. Greeter, is that you are not a historic preservation
I'm sorry.
board. My name's
Why,
Robert
well, why are you?
You have to go through the chair.
Yes, please speak through me.
Madam Chairman, I'm just stating,
Thank you.
and Town Council, I think, was very clear on this, and this is where we're running into this problem, is that the Historic District Commission is responsible for the exterior of the building and not the interior framing of the building. And I understand that there are particular members of this committee that think they're a preservation commission, but that's not your charge. And when I have to schedule threshold inspections, but when I cut a hole through a side of a building that's now going to be an interior wall, that's where I find it difficult to understand where we've gotten to this point. Because, you know, on my building card, there's a final HDC sign-off. And Linda, I agree with you, the property does need to be inspected on all four sides. And when I get ready to do that sign-off, I'll be more than happy to make an appointment with whoever from the HDC to go around all four sides of that building. But it's the exterior of the building. And I shouldn't have to schedule interior threshold inspections when I'm putting an addition on the side of a house and I'm cutting a hole in the wall that used to be a window that's now going to be an interior doorway. And I have to worry about whether or not I have to replace rotted wood, but I can't replace it because it's considered a historic structure. It's not. It's now become an interior wall. And this is where we're all getting confused, the builders in town, the architects in town, and I think your panel and your administrators. And from what I just heard from town council, to me it's very black and white, that you have your jurisdiction over the outside of the building and not the preservation of the materials that are on the inside of the building.
I think that we need a little bit more discussion on this because we,
Thank you, though, for addressing
we're
that.
trying to understand what we're preserving in regard to what everything that said, all of the about demolition. Because if it can all be demolished inside the shingles, then we're not preserving anything. But Lisa
I might-
Botticelli wanted to say something. Are you all
Before
set?
you have the comment,
Yes.
Mr. Chair, you know, that part, you are not a preservation commission. And really, you are really an aesthetics.
Mm-hmm.
I mean, I know it relates to preservation because you're
Historic.
you're ruling on historic aesthetics, you know, for this preservation purpose. But you're not there to preserve certain types of wood or anything like that. You're just there to preserve historic appearance depending on the setting. And, you know, again, the legislation is very clear about what you have jurisdiction over. It's exterior architectural features.
I think that we are not clear on that as a board, and I appreciate
Madam
the...
Chair, I think that what we've seen here is a demonstration of what the crux of the problem, that the HDC rejects its authority and is trying to decide what it wants to do instead of what it's legally empowered to do.
No, that's
You know,
what we're
and, excuse me, I'm speaking. And I understand that the HDC would like to do inspections of every aspect that it's approved, but the statute says that it has jurisdiction over what it can be seen from a public way, and there's a list of what counts as a public way. It's more than just the road. But when you're told by town council that you can't do that, you basically say, well, thanks, but that's not how we see it. And then when you're told that you don't have preservation jurisdiction, which I know I've made that argument on behalf of clients time and again, you don't see it that way. Well, that's what the law says. The law says that you can approve the exterior appearance of a building, which is strictly the skin. You don't have any jurisdiction over the framing. You don't have any jurisdiction over all kinds of things that you regularly exercise jurisdiction over. And this is why a lot of people, architects, homeowners, builders, lawyers, have a great frustration with the board because there's been such a creep of jurisdiction and it's become so ingrained and done for so long, and that people think that it's real, but it's not. And you know, it goes to a lot of things. Not only this board requires people to provide interior plans, and those interior plans cost a lot of money for architects to do. They take a lot of time, and they cost a lot of money to print. And if you go to the HTC 5, 6, 7 times, 10, 11 times, that's a lot of time and a lot of money. And it says twice in the HTC Enabling Act that you're not even allowed to consider it. But if I submit plans that don't have that, or if I show up at a meeting and I don't have that, I'm told I have an incomplete application and I'm not going to be heard, or the application won't be accepted.
I don't think that, I just want to respond to that quickly. I don't think that we do consider what's happening on the interior as far as layout, but sometimes it helps us actually understand the exterior by seeing how the walls fit together. That's my understanding of why we need floor plans. It's not about how you're arranging rooms and where you're putting things.
The idea that the
we don't
HTC
stamp
wants to,
them.
They're not stamped.
Yeah, the idea that the HTC wants to pick up people's curtains and wallpaper, you know, that's a bunch of baloney. Nobody really, people say that, but that's not what we're getting at here. There are reasons why interiors seeing interiors makes sense. For example, if you have a kitchen which has counters, or if you have a bathroom that has a toilet and a sink, then the windows in that area would generally be different than the windows in other aspects of the house.
Helps us understand.
And that's what I think the HTC wants to see the interiors for a lot of times, because it helps you understand why is this window different than all the other ones. And I get that, and I appreciate that. But the reality is what you should be doing is looking at these plans and saying, does this make sense? And conceptually, is it possible that that is historically appropriate, that that window is different because it could have been the kitchen or it could have been the bathroom? It doesn't actually have to be. It could be nothing. And that's the difference. So if someone wants to submit plans, they can, but it really only should make sense conceptually. It doesn't actually have to make sense. But then beyond that, this commission has put a form before people that asks them to submit to illegal, I would say, interior inspections. And there's a lot of pressure on people to sign that form because they want to get an inspection done, they want to get the permit done, and I think that form should be discontinued. You know, if you don't have jurisdiction, you shouldn't be asking people to volunteer to let you do interior inspections. The other thing is that we've had people be required to get engineers to do framing plans for buildings, and the justification is that, oh, well, we don't want to approve that change to the house because it might require you to destroy the old interior framing, and we want to protect that interior framing, so we don't want to allow that change unless you can prove to us that the change is not going to destroy that historic framing, the lumber that's inside. That is entirely an undue burden on that applicant and an illegal reason to make a decision. So I'm just saying, this is more,
Try to keep it one thing at a time.
If there are, I could go through, I will stop at that, but I think there are literally dozens of ways that the HTC exceeds its jurisdiction. It's not just about arranging the rooms in the house. It's about making decisions. It's about requiring people to provide expensive, time-consuming information that it's not supposed to consider, and it's about making decisions on things that it's not supposed to consider. Thank you.
Linda?
I'm not sure any of us make any decision on whether something's appropriate or not appropriate based on a floor plan. I do agree with Dawn that it helps me and several other members understand why the interior is driving an objectionable exterior architectural feature. But none of us make a decision based on whether the floor plan makes sense or whether you've got ridiculously large hallways and wasted space. I don't care about that. But it does help. But I do understand that at many times, I know what you're going to say, I do understand many times we start redesigning the interior for you instead of saying, look, that window on the outside is not appropriate, you figure it out. So I do believe that we do go too far on trying to rearrange the floor plans. I don't think that's appropriate, and I do agree with you on that one. But I think there's another aspect of this. You say exterior construction only, architectural features only. The problem is, we do have jurisdiction over demolition. And we have demolition by neglect statutes, and we have demolition so you can do an exterior wall or change that window or change that door that Bobby was talking about. We do absolutely have jurisdiction over exterior demolition, which then takes you into the building because that wall's disappearing. And that is part of the historic structure from 200 years ago. We do have jurisdiction over that. Nobody's questioned whether we have jurisdiction over a demo. So that goes a little bit beyond the shingles and the trim, okay? So it's when they're getting into, like Bobby was saying, getting into a demolition of a window to put a door in. We do have jurisdiction over that. We can tend to go too far sometimes in saying you can't remove something else and do something else. You know, it's a nuanced, unfortunately, it's a very nuanced thing. It's also a very subjective thing because that's how the statute was set up. It's very personal taste, and I think a lot of times our personal tastes outweigh what we should be doing. So it's not as black and white as I can see it from the street, or it's exterior shingles. We got a demolition issue, particularly with historic structures, not so much with something in Tom Nevers.
I think maybe if you're a little more careful in the application process, because you've got to take it case by case. If
Right.
you know, you're looking at, somebody's applying for, say, an alteration, and you think that that may result in a demolition of a portion of that exterior architectural feature, then you've got to address that in the application process and say, well, builder, what exactly are you doing? When you say you're adding a bedroom to this side, does that mean that you're removing the shingling on the side of the house? Are you putting it back? Are you adding a window? Are you taking a window out? You've got to address that in the application and then in your certificate of appropriateness. Because then, you know, your certificate of appropriateness is your binding document.
Right.
Once that doesn't get appealed by the applicant, then they're subject to the things that you have in there in terms of what you need to inspect from there. So if you need, if it is a mix of a demolition and a alteration, then you do have a right to look at what may be demolished if, you know, it ended up with a valid, unappealed certificate of appropriateness that has that condition in there, that you need to look at, you know, if they replaced a door with a window or a bathroom or whatever it may be, if it did result in a demolition. But you can't be doing it after the fact.
Right.
You've approved something, and you can't start adding new things that you need to inspect after. It has to be within the conditions of your certificate of appropriateness as you go through it.
We generally get demo plans if they're removing a whole-scale historic fabric of a structure. But that's what I'm saying. That then does go to the wall inside the shingles because that historic wall is disappearing or altering. So
Madam Chair.
tricky.
Mark wants to say something.
I just want to make sure that what Mr. Cohen is referring to is clear to everybody, because I think there's one opinion, but it may have a little bit more. In the special act, under section 9C, it specifically talks to the Historic District Commission shall not consider relative size of buildings in plan, interior arrangement, or building features not subject to public view. My understanding of that was, as we've gone over the years, because this has been over 50 years now, the commission has been looking at things like this, and that they were able to look at things in plan, but they were not able to deny something or review something saying this bedroom is too large or anything about the interior arrangement other than how it may affect those exterior architectural features. That's been our understanding. I think that's the way we've reviewed it. To Mr. DaCosta's point about threshold inspections, on that particular project, Bobby, the idea was at the commission table, the applicant agreed to that inspection because the commission had a hard time allowing that addition, which was going to affect the exterior architectural feature of that wall. The only reason I came inside of that building was because you guys asked me to. Right. And I've been in many buildings because people have been very giving of letting me see things, but I've never inspected the interior to make sure that this has to stay unless it is that exterior wall. So that would be a great discussion to ferret out, and I'm sure it'll be much longer of a discussion, and we can deal with that. Just so that's a
Just
little
to
bit
follow up to
clear.
that, Mark,
Sure.
this is where I get confused, and since we have counsel here, I'd like some clarification. On a historic structure, it's having an addition put on the side of it. So in other words, the exterior wall now is going to become an interior wall. Does the HDC have jurisdiction to say to the applicant that you need to keep the sheething on that wall? Can that wall, because basically what, in this particular instance that Mark's talking about, we left the sheething on the wall, we stripped the shingles off, we left the sheething, and we put the blue board, the plaster board, over the existing sheething. But the wall had a big bow in it, so we couldn't straighten the wall because we made it work, that's a long story short. But do they have the authority to say, you have to leave the sheeting, or do we, as builders, have the ability to say, it's now become an interior wall of the house, we have a new exterior wall. Can we straighten this wall, can we remove the sheeting, can we insulate it, can we bring it up to code?
Yeah, no,
I'm lost there.
yeah, no, the way you described that, they really don't have jurisdiction to be in there looking at the interior, because where the approval was.
But it was exterior to start.
Demolition, because now we're removing the exterior wall. But what I'm asking is, since I'm making that exterior wall an interior wall,
Right.
does it no longer fall under their jurisdiction?
Yes, that's phrased that way, it does not, because what you've done is you've approved the demolition. You've approved the alteration of the exterior feature. So once that's approved and that's altered, you're not a historic preservation commission to go in and make sure that he kept beams or certain materials on the interior, so.
That was a condition of the approval.
But then potentially the addition doesn't get allowed is where what the applicants are up against, because when you know the wall's going to get demolished, you might not approve the addition.
Madam Chairperson, point of clarification.
I have a lot of people who want
Point
to
of order.
speak, and I'm going to Matt McGecker next.
Point of order.
Yeah, hold on, point of order.
Come on, please.
Point of
John
order.
can't hear.
Right, Madam Chairperson, I'd like to explain something. As a clarification point of that one detail of exterior architectural features. All right?
Point of
There
order.
are 7 to 8 exterior architectural features of a structure. That's all. I've said it for years, you cannot go inside the structure, no matter what you've got old beams, you can't do anything with it. And I said it for years, and nobody wanted to listen. No, it looks all right, we have the control. All of a sudden it came, ended up, I think, a court case, and the judge ruled. He made the decision, and I go along with it. I want to say this. I've got over 42 years on this commission. I've seen over 50,000 applications, and I've seen a lot of changes in this community. And my own self, I've always stuck and consistent to those 7 items of a structure. They have gone down, he told one fellow, I'll say this, one fellow took a roof off of a structure.
Madam
I will
Chair,
explain what can happen.
Matt McGeckern's going to
You'll
speak
get your
next.
chance, Mr. Cohen. All right, I just want to explain a few things.
I agree with you, John.
You want to talk?
I said I agree with you, but
Yeah, well, I thank you, but
One person speaking at a time, please.
I just want to explain. In the violation section of it too also, well, when there's a violation, just to stop a lot of this talk, I hope, and go on to other things. And guy took the roof off, got a flint. So took him to court, fine. Judge ruled that he was in violation completely, that he, in the roof, that he took it off, he demolished. That's what he got. All right, we were told by the judge, this man was fined, heavy. Only thing we can ever admit is that it was well over $20,000. That's a heavy fine, but the guy was in violation, the judge done right. And I think that there should be more of this done with these small minor violations you see around town. There's a lot of them. But as far as, and then one more point, the attorney for the town says that it can be seen from the public way, travel way, right? Also, it does state in the next sentence, which I didn't hear anybody mention, it says, any subdivision road approved by the planning board. So if somebody puts in a 100-lot subdivision, you don't just go up to the town road, look in. You go all through, and you have to be sure you can see from one street to the other. So it covers a wide variety for viewings. So I just wanted, that'll stop a lot of questions. I know they're minor, but there was a lot of questions, but that stops a lot of it. There's 8 items used to go by, and I think the commission should tighten up on it in the old historic area downtown and in Squansit. Thank you.
Okay, thanks, John. Matt?
Sure, I just have a quick kind of a scenario just to give you. By nature of approval, or say if you're doing an addition to a historic structure, and you basically say that you're going to replace the roof shingles, all the exterior trim, replace the windows, that approval in and of itself, then as far as I understand what you're saying, and I'm not saying I'm promoting this, but at that point, the interior structure is not under the HTC's jurisdiction. Is that correct?
Yeah,
There's no demo involved.
Yeah.
I'm using that as an example because, say, for example, the roof rafters are rotted, and the contractor has basically said, okay, let's replace these. Again, this is not something that people are promoting, but if they were to replace all of those roof rafters, essentially rebuild the structure from the inside, would that be a violation?
no, I don't see how it would be.
I think the big question that everyone has is, then what constitutes demolition? Because taking the shingles off, I mean, the shingles, buildings get reshingled
There's no historic
every so many
shingles on the
years.
sign.
Yeah, and trim and everything, I mean, there's no, so we're just, I just.
Both of you stop.
I just want an answer to the question of, are we just preserving the look of the buildings in Nantucket?
Yes.
Are we doing Disney World
We
here?
have
You're
no,
doing-
everyone can go in and replace every interior piece, every exterior wall with steel.
Yeah, I don't mean to be facetious
just
about
wanna
this,
be
but it
clear on
says, it's very clear. In passing upon appropriateness of exterior architectural features, you shall keep in mind the purposes set forth in Section 2 of the Act, which has to do with the preservation and promote the general welfare through the preservation and protection of historic buildings, places, and districts of historic interest through the development of an appropriate setting for these buildings, places, and districts. And then the vacation and travel industry, how that's promoted through that. And then to protect that interest, which is essentially aesthetics, in passing upon appropriateness, you shall keep in mind, you shall consider the general design, arrangement, texture, material, and color of the building or structure in question, the location on the lot, and the relation of such factors to similar features of buildings and structures in the immediate surroundings. So essentially, yes, you're protecting historic setting, not historic building materials or the like.
That's why it's,
Building materials as related to exterior architectural features.
because it specifically says, for the preservation and protection of historic buildings, and then I agree with Bobby and everybody in this room. All of this contradicts itself, depending on the law and how other people just read it and interpret it. How can you preserve any historic building by this jurisdictional
That's
The
limitation?
whole point. You don't have the power to preserve.
that's
it.
the
I didn't
interest.
ask that question. I asked my question.
Right, it's a good
Stephen,
question. That's the
let me recognize
the
you
interest.
before you speak.
Yeah, that's the interest protected by the Act. That's the interest. It's the preservation of historic buildings and settings.
How are you going to do that if it becomes steel? It's like Disney World.
Because if you can tell that it's steel from the exterior, it's not approvable.
But then it's not an historic structure
But
anymore.
if they come in for an approval of an exterior architectural feature that's shingles, and you approve shingles, you're not entitled to go into the building and see if they put steel on the inside behind the shingles. You're not.
So it's not a historic structure anymore, so it goes off the grid.
Well, that's, again, you can only go within the commission's jurisdiction, exterior architectural features.
I'm not saying what you're saying isn't correct. I'm just saying it contradicts itself from the language, because in the same sentence, literally, it says preserve and protect historic buildings, and then the next part of it, the interpretation is that we don't. And I don't know how you
You're
reconcile
preserving the
that.
setting only within your jurisdiction, which is exterior architectural features. I should point out, because it's a good point about Disney World, and it kind of explains the distinction. Your jurisdiction really isn't to preserve Disneyland or to be a anti-snob act or anything like that. It's to preserve history, a setting in a particular place. And this is where your building with Nantucket comes in mind. What you're preserving may not be the greatest structure in the world. It's not a matter of taste. It's a matter of, in this historic period and in this historic setting, we had this type of house. And it had a single entrance to the front, and it had 2 windows on the side, and it had this type of shingling. And that's what we want to preserve in this area. And when we go out to the hillside and we see low landscaping, and we can basically see almost to the ocean, then we're preserving a certain setting there. But you're always, so you're not saying necessarily we want it like doll houses everywhere. You're just saying that you're preserving the particular historic setting of that particular part of the island.
But essentially, you're saying
First time I've heard
that
this.
we could go to Main Street and tear everything down, and as long as we rebuild it and it looks exactly the same, we're doing our job.
No, because that would not be, no,
but
because that
essentially
is,
that's what can
that's
happen.
building materials from the exterior architectural feature. So you do have the ability to regulate the building materials for, say, a brick residence on Main Street. You can say to the applicant, no, you can't put that type of,
No,
using it as a
but they
hypothetical.
could take down the whole building and rebuild it out of brick.
No, because it would be a demolition then, and they would have to prove
But
why
that's
they're
what we don't
entitled to that.
understand, because essentially, I'll get you in a second, they could, they could demolish it from the inside, any of these structures.
So what the hell are we preserving?
So we just, then you might as well just let them take it down and rebuild it. But
Take every
Lisa, go
building down
ahead.
in town.
As a professional here, I think I'll speak hopefully for everybody in this room. Nobody's desire is to take down buildings on Main Street and to build them back with steel frames. The point is that we're trying to renovate buildings in a responsible way. We all love the historic nature of Nantucket, and it's just trying to come up with an understanding of what the jurisdiction is. I mean, to have to go in and restructure a roof because it's undersized, I think is a legitimate concern and something that we'd like to do. Nobody's suggesting that we make it Disneyland and take down all the buildings. We're trying to do it in a logical fashion, and it just seems like we haven't been able to do that. And I know sometimes it goes a little bit further where every single piece of wood in a structure is replaced, but I think that's unusual, frankly. And I think that in most cases, especially in the Old Historic District, that people are working with the structure and really believe that they should be. But that the jurisdiction goes a little bit too far sometimes in terms of what we feel like we have to come in and ask for.
I understand that, but I think that our confusion is from what we're being told. Maybe that's not what people want to do. I certainly hope it's not what people want to do. But a lot of the way things have been being done is because the HDC has had an understanding of what our jurisdiction is, and I think we're being told that it's really not that, and things could be being done a different way. And I'm going to an extreme, saying you tear everything down and rebuild it the same, but I'm trying to understand that, can that happen? Because in certain cases, people do want to do that.
You'd be able to deny that. Because if somebody's saying, this is a pain in the neck to upkeep this brick building because it leaks, so I'm going to knock it down and I'm going to build a replica of it, you can deny that. You can say, no, that's a demolition, you don't qualify. The view is, we want the brick from 1890, which is on 8 of the residences in this particular setting. You can stop that demolition.
On a brick building, but on a shingle building, we have to let them replace the shingles on a regular basis.
Replace, right, well, maintenance and upkeep, but they're
so
not
the
entitled
wooden
to
structure
knock the
can be
building
torn
down and then
from the
rebuild it.
You
The
can play
wooden structure can be
games.
torn down from the inside, is what I'm saying.
Yeah.
You put the shingles back up, you put the sheathing back up, then all of a sudden, what we're dealing with a lot is gut rehabs. And everybody in here has been involved with a gut rehab. Generally leave the outside walls standing, especially on the historic structures. But you're creating a scenario where, okay, they came in, they got new shingles, they did all the whoop-de-doo on the outside. Then all of a sudden during the gut rehab, they've braced these things and they've ripped out every piece of structure, which means that is no longer, it may be sitting in an historic location. It may be sitting on Main Street. However, the original historic structure from the inside is no longer there. So it is no longer an historic structure. And it's sitting, and that could theoretically, long after we're 6 feet under the water, that could be going on all over the historic district to the point of where there's not an historic structure left.
Right.
So that's what you're saying. We
But I'm
can't stop
saying
that.
that-
We're not the preservation,
Right.
right? I agree completely with everybody in here. We are not the preservation board. But using your scenario and going to an extreme, there could be not a single shred of historic structure left sometimes.
In terms of what the Nantucket Historic District Commission has jurisdiction over.
Well, nobody can stop it after that, once the exterior is done.
Well, there's
So-
this, again, you're not an historic district, you're
Right.
not an historic
Historic
preservation
preservation.
commission.
Right, and I get that.
I think
Stephen?
that, thank you, Madam Chairman.
He's taking.
The really important point here, and actually one that got said before that I think should be emphasized, not only, essentially, it's not that people don't want the HDC to do this and to preserve things, it's that the HDC doesn't have the legal authority to do it. So just because what you want to do is important, doesn't mean that you suddenly can do it. Like the police have the duty to serve and protect, but not by any means. They have limited tools, and they can't just do anything they want to protect people. And the HDC can't do anything it wants, or even more than it's legally authorized to. And I don't appear before you and make basically the same arguments that town council has on a regular basis because I'm encouraging people to knock down historic structures. I'm just saying on a regular basis for my clients that you don't have the legal authority to tell people that they have to preserve, historic materials. The statute doesn't distinguish between old and new wood or old and new materials. But before when we were talking about whether or not you would have allowed a demolition, an addition, without the condition that the historic material inside be preserved, I thought that was a very interesting point because the whole point of your jurisdiction is to determine whether or not the addition that's being requested is historically appropriate. And the consideration of whether or not that addition would impact historic material is not a valid consideration. That is something that you care about, and that is something that is important, but that is not something that's in your legal jurisdiction, but it is something that's done on a regular basis. I
want you to read the
and I
section
would
on
note,
demolition.
and I would note that, there's a lot of problems with these kind of things, because you think, or the HDC has said, we won't approve this unless you preserve that.
I think
that's
that
not
we
accurate.
know what your arguments are.
But I also don't
we
feel- I
are
don't feel
trying
it's
to, at
accurate.
this meeting, get opinion from our
Everybody else.
council so that we know clearly what our jurisdiction is.
I
And
think it's an
that's what
excellent
we're trying to get at. But if everyone keeps talking to us and telling us what our jurisdiction is, we can't discuss it and get an opinion.
I think that you should ask council that exact question.
That's what we're
The question
doing.
is, council, if someone wants to put an addition on the side of a historic structure, can the HCC deny the addition based on the fact that the applicant is not going to keep the historic siding on the side of the house? Do they have the right to do that? If the addition is historically correct, comparable to the other houses in the neighborhood, the shape, the size, the pitch, the materials, the windows, can they say to the owner, we're not going to give you this addition unless you keep the exterior siding, which is now interior wall?
Yeah, no.
He already answered that.
Yeah, but emphasizing
that's not
that
a
brings it up.
question.
It does clarify it a bit because it goes again to your jurisdiction is over exterior architectural features as they relate to that particular setting. So the fact that you're preserving, a brick mansion in one spot, you're not preserving that out in a bog or something like that. So what you're doing is you're viewing that proposed exterior architectural feature, the proposed alteration, in context with that setting. So if you determine that that addition is inappropriate for that setting, then you deny that. But you can't deny or condition that question on what he's going to do when and if that addition is on the building. Do you see what I'm saying? That's the distinction.
What if the addition knocks out an entire historic wall
Right.
by demolition?
We have jurisdiction.
Where your
over that.
relevance is if you say, in this setting, you're not entitled, it's not appropriate for you to remove that particular siding. that angle of that house, the way it sits on the setting, is we want to preserve that structure. We don't allow you to build a addition on that because it's not appropriate for this setting. If you make that denial, then it'll be the applicant's burden whether or not they want to appeal that as to whether that was arbitrary and capricious. But if you go ahead and you do say, no, we can find that appropriate for this setting, then that ends your question. You're not entitled to then see what he does with the interior if you've approved his exterior alteration. That does highlight the distinction.
So in regard to what we're preserving in terms of demolition, is it that we just don't want the way that structure fits in to its setting to go away?
Yes.
But people can essentially rebuild it any way they want from the interior,
Once we approve the addition.
as
Well-
long as the shingles are.
They can always do whatever,
What
in terms of, not other jurisdiction, like the building inspector, but in terms of
Right,
your
no,
jurisdiction,
our
they can do whatever they're doing that they want to do on the interior of the structure. The only time you come into it is when that alters the exterior architectural features.
But essentially, they could rebuild it from the ground up.
They could
as long as
rebuild
it
it
looks
from the
exactly the
inside
same.
out, if it looks
Inside out.
exactly the
But
same.
not from the ground up.
But they can't raise it. If they were to say, I just don't like the maintenance burden of this brick house anymore, so I'm going to raise it and I'm going to put up fake brick, and guess what? You people can't tell the difference from the street. You're going to have to say, no, we can tell the difference, and that raising, we do not permit
No, but
in this
but
situation.
That's a clear distinction, but the key here is that they will say, potentially, or more realistically, I want to build it, and I'll even reuse the bricks that are there. So that's really where we are. I mean, it's pretty easy to tell the other example that out of fake brick or something. Sure, we really understand that, but we get down to a point where, as Don, I think, was trying to get to on Main Street, rebuild it with all the components that are still left, and we'll get authentic material to put back.
Yes.
So we'll rebuild Main Street, and it'll all be modern inside and everything else, and understanding that's what they can do now. But you're saying they can't raise it, which I think is
That's
we have a real thin
What we don't
slice here. that
quite
we're-
understand.
Well, I can't rewrite your legislation for you. I mean, that's what it is. You're-
Actually, you could.
Yes, you can.
Well, we can do that, but we can't right now.
Lisa,
right,
did you want to say
right.
something?
No.
Rick? Please just state your name.
What you're saying is that their jurisdiction continues on that individual building and the entire street that it affects. Is that not true?
Well, they have jurisdiction.
Historically, their job is to look at that building. If the addition is going to affect the entire vision of that street, that's their jurisdiction.
One thing within their jurisdiction, yes.
Yes, and so that also applies to if the building, if, you know, the raising of the building, the changing of the pitch of the roof, and how it affects everybody else on the street.
Absolutely.
Mark,
Similar question.
please state your name for the record.
Mark, so if we were to use kind of a funny example, this building, for example.
Bad example.
I had to, sorry. So, kind of also, if we were to, let's pretend this building were 200 years old, and the organization comes and says, you know, the floors don't support the loads any longer, we can't hold the capacity we'd like to, but we're going to keep the entire exterior just the way you see it today. We're going to make repairs, but no alterations, we'll keep all the windows and so on. What we would like to is reframe the roof, we're going to drop the floor out, put a new floor in, drop the next floor out, put a new floor in, and we're going to reinforce the foundation from the inside, but no exterior change. Is that permissible?
Pretty much is.
I guess, and last question I have, back to inspections. If the applications are approved from a public way, many of the time we've had an application approved where you can't see it because it's 800 feet back from the beach and you can only see from the second floor up. Yet if the administrator is walking the property and reviewing items that were not in play during the review process of the design itself at the application table or at the table, is that really permissible, or should they just be walking the beach, the street, and the public path that encompass the property, but at no point should be walking on any private property unless invited in? Is that accurate?
Pretty much, yeah.
Thank you.
That doesn't mean you can make the house pink and purple and stuff.
I mean, and it doesn't mean, this is also in your legislation, it doesn't mean that an applicant is entitled to mislead you either, to say, all right, well, here, administrator, look, here's the tree line and you can see this house, and then lo and behold, you do get information that comes to you that, it is a sham, that there's some type of modernist, whatever it may be, that, is the sham that they're maintaining on top of the tree line. I mean, you can take this to, absurd results. In that situation, you can take some action
I think it
about
would be
it.
helpful to have the commission identify what they think is visible and what isn't during the review.
Okay.
I mean,
Right, I have a
otherwise-
very specific question.
I do too. Let me go first. Materials. Do we have any jurisdiction over materials that are not visible from a public way?
No.
So if someone wants to put vinyl siding, for example, on the back side of their house that's not visible from
Yeah,
anywhere,
no, they can do it.
they can do it.
It's not a permissible material to be used on
But you're
Nantucket.
not,
But we
they're
don't have
not
jurisdiction
seeking approval
over
from
it.
the
Paint polka dots they can do.
They have to explain everything they're using on the house when they come in on the application page.
Yeah.
And we see it, and we say no.
What about it?
But
What about from
That's
there?
sort of the point, is that the
Right.
HTC is exercising jurisdiction over things it doesn't have jurisdiction over.
Okay, I didn't recognize you.
Mark,
I will. But let me finish this conversation first.
It has to be visible from your public areas.
Does a public way constitute traveling in the air?
That was the question.
Yeah, it's defined.
I don't think it does.
So the public who's
Just bear with me one second. Let's just be clear on it, because we keep trying to, we keep dancing around the issue of what part of the house that we can peek at. But it's right here. It says, such views as are open to view from a beach, a public way, a traveled way, a street or way shown on a land court plan or shown on a plan recorded, a proprietor's road, a street or way shown on a plan approved and endorsed in accordance with the subdivision control law, a public park, or a public body of water. And then it goes on, architectural style and general arrangement, building materials and all of that stuff. But I just told you the areas.
a traveled
of
way
view.
is an
So, yeah,
airway.
no. A helicopter, no. An airplane, no. But,
water.
my gosh, a body of water, that's the Atlantic Ocean. You
From a
can-
boat.
Yeah, you can see a lot of Nantucket from the Atlantic Ocean. You can see a lot of it from public parks, private ways, traveled ways, subdivision ways.
what about a paper road?
Did you hear it?
Okay, because we use, a lot of times we'll use the
Can you just try
potential
to
for
keep it
opening a
brief
paper
so we can
road.
Very
move
specific
forward?
question.
Go ahead.
The commission often conditions its opinions on, or its certificates of appropriateness on deed restrictions. And sometimes those deed restrictions are over vegetation, sometimes they're over preservation of interior features. For example, the beams above our heads, there's a deed restriction on them. I don't see anywhere in the legislation where it has the ability to do that. Do you, town council?
Yeah, we've.
This wasn't for HDC.
Okay,
It's not a good example.
Then that is a bad example, and I apologize. But there are,
As I said, bad
there are
example.
dozens of deed restrictions that have been demanded by the HDC in exchange for certificates of appropriateness.
That's later on the agenda.
That's later on the
Yes,
agenda.
we are going to
Steve.
discuss
You
that.
got to stop taking over the meeting.
Chairperson,
Yes, John
in
McLaughlin.
respect to that, as what the town council just read, it also states in there, and it has since the beginning, the commission cannot make a decision where something is obviously incongruous to immediate surroundings. I've always thought that immediate surroundings on any street would say be 300 feet within it, 200 or 300 feet. That's been my general consensus because it's not laid out. Now, in the viewings, you mentioned seeing the top of a tree, a house. All right, should we be taking shrubbery as a blockage from view? That's the way I should we, because the hedges are all over the island. There's some you can't see. In the winter, you can see right through the hedges. So should we accept screening from, as shrubbery and stuff?
It depends. It goes back to building with Nantucket in mind.
Right.
Because that specifies various parts of the island where shrubbery may be appropriate, and in instances where shrubbery is entirely inappropriate, even if it's blocking the view of the structure. Sometimes I saw in building with Nantucket in mind, you actually want to see the structure. You want to see you know, a simple one-story structure with maybe an extra story, depending on how the hillside, you know, how the landscape appears in that area of the island. Remember, the whole island is under your jurisdiction. Other areas where you have a setting of a ship's rail fence, you don't want hedges blocking the exterior view. So it depends on the property in question. Sometimes the alteration, you know, shrubbery would alter it, but you don't want to have a situation where you're allowing a major renovation of exterior architectural features and, yeah, we'll just put up a shrub in front of it, therefore it's not in your jurisdiction.
Well, there's a lot of that.
There's a lot of that.
Well, but, you know, that's something we need to emphasize here. You know, I feel like, I only stay with legal advice, but I feel like you're, you know, being a bit attacked here. But the fact is there are legitimate, huge areas of great public concern within your jurisdiction that you already need to deal with. So I would recommend strongly you don't pare things down in hypotheticals that can lead you to various illegalities or illegalities. Take them one step at a time, try to maintain your view of what's within your jurisdiction, and apply those standards that are so well set out in building with Nantucket in mind, is the best advice that I can give to you on all of the issues that we have here.
Sometimes
Not
they
to
will
belabor it, Madam Chair, but one thing I
there's
had
someone
was
from the audience that wanted to speak.
if somebody wants to build something, and we, at the time of the viewing, it's screened, you know, we could use that, so, you know, at the time of the viewing, we have pictures that were screened.
Yes.
But if they build it, put the screening up, and then they come back and say, well, I don't need a permit, no, that's another problem. That's
Right.
why I've always felt, you know, that just say we don't accept any screening like that. You might put a 6-foot board fence, that's fine, you know, but anything above that, you have visible. Thank you.
I should have said this first. You just said attack, and I don't think we're looking to attack you, and I know there's a lot of confusion all across the board, but I mean, this board is, I believe, among the oldest in the country, and I think its enabling legislation is also among the oldest in the country. I think we're all quickly concluding here is it needs a complete overhaul. And I think we can get it to where you and maybe where we would all like it to be, so because I think we all actually have a lot of the same goals, believe it or not. But the enabling legislation doesn't do that currently. And I think we can work together so we can get it to a point where it's achieving what we all want it to do for Nantucket, because I think we all care about this community. That would be a great thing. But until we get there, we're unfortunately working with what we have.
Okay. Linda?
To take it back to the screening issue, you could napalm this whole island. I mean, when they first came here, there were no trees here. So when somebody comes in and says you can't see it from a public way, because you have trees, not because of topography that doesn't change, or a house in between you and the house that you're talking about, and you have trees, or you have scrub oaks, or you have pitch pines whose life expectancy is 20 years, they fall over. We could theoretically say, no, that architectural feature may become visible should the screening burn or fall over. So you're saying that we can do that? Because what John's saying is that he's not comfortable making decisions on an objectionable architectural feature because at the moment it's not visible. But you could always take down the shrubbery. Somebody could always plant a lawn instead, and that feature becomes visible. So you're giving us a little bit of wiggle room to say that it may become visible, so we have to address this objectionable feature, because that shrubbery and those trees may not last for 20 years.
But you really have to look at it in the point in time in the application. That, you know, is it an exterior architectural feature that's visible or not?
But it could become visible.
It could become visible, and it's probably partially visible, regardless of some shrubbery or a tree which may or may not come down. You probably are, as a practical matter, saying that, I mean, you wouldn't know it was there otherwise. You could probably see some part of the exterior of most of what you're talking about, so that you're not, you know, playing this exercise of, you know, a game of whether I can see it or not. You're really talking about your exterior architectural features. You know where these structures are, and you know the different parts of where there's heavy shrubbery or vegetation and where there isn't. And you know what settings you're trying to protect. in that particular instance. You got to take them case by case. I mean, that's the best I can tell you.
Okay.
That's what makes this all subjective. It's a very difficult process.
Can we move on to the next item? So 5B Mill Street
I don't want to talk
and inspections.
I think we dealt with
This is your legal opinion. I'll just jump in real quick, but we talked about it. We have the butter here. I don't know if the property owner's here or not. And I think we just need, it's really to fill you guys in on the aspects of, we had a typo on our agenda where it listed the incorrect time from a previous agenda that, we borrow and then we, update. And so we have the abutter who was misinformed by us, so it couldn't be at that meeting. So the remedy essentially is to, and I've already talked to the property owner, like I said, is to reschedule the hearing so that the abutter can have her comments entered in. You guys should then look at the application and rule on the application at that time. So that's really the update, and that's the, and it has, there's other parts to this too, so, and I think the abutter wants to say something at some point.
Should we be then, are you looking for us to make a vote tonight to rehear this application?
I think George had an advice about.
Did you actually issue a certificate of appropriateness?
Yes.
I would vote to rescind the certificate subject to a rehearing after proper notice, including the abutter.
Didn't this also happen down on North Beach Street? Did that one get clarified too?
That went to appeal, and that's all done.
Okay.
That's different.
I'll move that, Madam, as my motion.
But before I take the motion, will that satisfy you if we make a vote to rehear the application rather than giving testimony in regard to the application this evening?
The application's not properly before us, right?
The application's not before us, so I
Okay.
don't want to discuss the application.
All right.
But will it satisfy you if we make a vote to rehear the application?
Yes.
Okay.
You need to identify yourself.
Carolyn Crowley, the abutter, at 7 South Mill Street.
Thank you.
But I also have some questions, and we have the attorney here. Could I ask them?
It
In
depends.
regard to the specific application?
Exactly.
No.
Not the merits.
I think you
You
can
could-
take your vote, and then I think she has a specific question for town
About
council.
procedures, but not about the specific
Okay.
application, okay? So let us go ahead and move that motion.
Motion.
All those in
Wait a minute,
favor
what's the motion?
to rehear 5B South Mill Street, to put it on
To
the...
rescind the COA?
Rescind the
And
COA.
mark it for rehearing
rehear
after proper notice. That's your motion?
All those in favor of that?
Aye.
Any opposed? Motion carries unanimously. Now, if you have a procedural
No, I think I'll
question.
just go to the hearing
Okay.
and find out. So you are rescinding the COA for the house?
No,
For the most,
it was for
approval
the
where...
fence application. For the fence.
For the fence?
The fence happens to be on top of the wall, so that's why
It's
it's,
the
I know it's
fence.
confusing, but it's for the fence that was applied for, previously approved, now it's been rescinded, and will be scheduled for a rehearing. I was going to address this, Linda.
Yeah.
It's not the notice you're thinking of because of the other
agenda.
application. It's because there was a defect in the notice of the time on our
Okay,
agenda.
so it has nothing to do with the
It was the-
defective
it was
notice
the
as far
agenda.
as 1,000 feet.
Right, no, it's not that. It was the
Fine.
agenda.
She didn't have a fair
So-
chance to come and speak it to you guys at the meeting. That's essentially what it's for.
Be in touch with the office about when it will be
Yeah.
on the
Okay.
next agenda. Okay?
Will do.
Thank you.
And our office will notify Bernard that this has happened?
Yep, we've already been in contact.
Joe, did you have a question?
Yeah, I have nothing to do with that.
Would you come close? Anybody speak up, please? I have a slight
Joe
hearing
Paul,
problem.
HTC architect. I'm just curious, the HTC has the power to rescind the certificate of appropriateness?
Well, it was granted without proper notice.
Oh, yeah.
Okay.
Not because we feel like it.
willy-nilly.
Okay.
Yeah.
You never know.
Whereas you're all rescinded.
Madam Chair?
Yes.
I would just have one
You want to
suggestion.
clarify that?
No.
Okay.
No, we're done with the...
Okay.
Okay.
I would just have one suggestion would be, I would have your commission cover with council your list, and then maybe take public questions,
Okay,
because
because you,
This is just
Yeah.
getting dragged.
yeah, it's going on.
I think we hit the big part, but
Yeah.
Procedures to rehear.
Okay, well, I think we've got that.
That was just that one.
Number 3, town council opinion enforcement guidance.
Enforcement guidance is
I
just
feel
the...
like we've covered.
Yes, it's the mind-numbing letter spelling out, if you
Yep.
want to follow all the options available to you, it's spelled out right in that letter. Feel free to follow it or not.
I think we'll entertain that as we move forward.
Okay. Deed restrictions, you gave us an opinion on that.
The opinion on that is self-explanatory. If you have any questions about it, okay.
I do have one procedural question, Madam
Go
Chair.
ahead.
Did you suggest that we put that on a subsequent meeting to ratify as conditions those things? Or how do you want to deal with these deed restrictions we've already forced people into? What the heck?
Well, I want to make sure that we haven't forced people, they've come to the
They agreed to
HDC asking for what otherwise is an inappropriate feature. You have been, I would say, user-friendly to, I guess, our fault now that you found a way to use one tool to augment a way to approve something that otherwise would not be approvable. So,
What I would recommend at this point,
I'm saying, what do we do
for
with the
the
existing?
for the practicality of it, is to take things one step at a time. I wouldn't do that anymore as part of your application process. We've spelled out in the letter what you can do if you want to follow along that type of
Make it a
process.
condition of a COA.
Yes, just quickly, you can put your condition in the certificate of appropriateness or adopt conditions, incorporated in the certificate, and then you could enforce those conditions if you think that they're being violated.
For how long a period of time?
Forever, because you'd have a certificate of appropriateness that's valid and enforceable in perpetuity. So that gives you that. It doesn't give the extra oomph that is on the chain of title.
Right.
But if in an instance where it is a matter of particular importance and something that you really are concerned about, that the test of time will enable something inappropriate to become visible, then as your existing scheme, what I would recommend you do is condition for the applicant to present a deed restriction to be accepted by the Board of Selectmen, which is under your existing town charter. And then you can have that in the condition in your certificate of appropriateness. Then they have to go to the proper board and get that deed restriction accepted. Then that will get recorded on the chain of title.
So we can defer that kind of action? Because I know at the ZBA level and the planning board level, you cannot defer to another board.
Well, you are basically acting, you're suggesting it, you can't force the Board of Selectmen to accept it.
If they don't accept it,
If they
then
don't
they're in
accept it.
violation of our COA.
If they don't, no, because the applicant, all they agreed to do was to present the deed restriction to the Board of Selectmen. And again, I'm talking about your existing legislation and options. Other options we've spelled out are in the letter. You could get town meeting approval to grant that authority to the commission. It's
Or we
another
just
thing you
make it a
could do.
condition of the COA. If they haven't met that condition, they can't get a sign-off. Or as Kevin asked, if they somehow, there's a condition on the COA that they maintain this tree, in 3 years from now, they remove the tree, you're saying we maintain control over that tree. Because
Yes.
it's a condition of the original COA.
Correct. It would be a matter of enforcement. Where the issue came in that Mark had raised is that you're concerned that it doesn't get, a subsequent owner doesn't get notified of it, and then they make alterations.
Right.
And in that situation, you're just dealing with an enforcement issue with the certificate, or you could go through the process where you do instruct them to, or you ask them, you put it in as a condition that they do present a deed restriction to the Board of Selectmen to be accepted, then that would be recorded in the chain of title.
But that would come after the certificate of
It
appropriateness has
would,
been issued.
but you can't condition it on them getting approval from the Board of Selectmen, because that's within the Board of Selectmen's
Right,
jurisdiction.
and that's deferring action to another board.
Right.
Based on what our decision
If you
was.
really want this power yourself in terms of your actual deed restriction ability, then I would do it as a matter of present it to town meeting.
And we can put addendums on our COAs. I mean, you're not
Yes.
going to fit it all in that little
You can
community
incorporate,
thing.
right, you can say, we incorporate the attached conditions.
Exhibit A or whatever.
Exactly right.
Right, okay.
And one other thing, I need to point this out, because this keeps coming up. Well, we keep doing it, we do it, they agree to it. Okay, that's fine. You can get somebody to agree to almost anything. But number one, it doesn't mean that they can't then challenge it on appeal. And number two, it doesn't mean that it's valid. So if you did get something that's invalid, then it's not enforceable anyway. So really what you want to do is do things that do give you that enforceability down the line.
Town council has asked that we go through the rest of his opinions
Without
and then take
doing that.
questions or comments. Can you hold that? Okay. So can we move on to the Mullen Rule?
I think we got an opinion about
We got
that
an
last
opinion
week.
about that.
Yes, early this week, and that's a very short opinion. Basically, you cannot use the...
form
the
that we-
for- You can use it was an excellent form that you're using for members to certify missing a hearing, and they've reviewed the materials.
Right.
I love that form, that was excellent, and we approved that. The form that you should not be using is where you get a
That's the
waiver
waiver.
of a consistent quorum.
Now, can they ever waive a consistent board, or did the Mullen Rule sort of just kick that to the curb, and this is all we've got as a tool is the
Yes.
Mullen Rule?
Yes, and keep
That's what
in
I could
mind-
not get an answer
I
that
have a
day
question.
about that.
Right.
Now, do we need to put all those 6 or 7 things back on the agenda to ratify the approvals again?
I would leave it, yeah, you could.
Nobody's appealed
If there are-
them. They're gone
Yes.
beyond appeal.
Yes. If there are distinct ones that you know about, you may want to ratify them.
Otherwise, we just leave them
Yeah, leave
lay?
them. Yeah.
Okay.
In a case where they have lost the ability to get a quorum,
Right. Start it over
can
again.
can we do something where they sort of can resubmit
Tell them
without
ahead of
having
time
to pay
where-
the fees again?
Yeah.
Waive the fees anytime we want.
Have them resubmit by waiving the fees. Tell them ahead of time, we don't have a quorum. We bump it, without us opening the hearing. There are ways of dealing with that. I just want to point out to you, Mullen Rule gets a little bit confusing. Mullen Rule says that you need, anybody voting on the application had to participate in the hearing process at every session of the hearing. And then when you vote on it, those people voting on it had to have attended all the sessions. What a lot of people confuse is the statutory exception to the Mullen Rule. What the exception to the rule is in the statute that we provided, and that's where you can have multiple members missing various sessions, but you can't have any one member ultimately voting on it who missed more than one. So you could have 3 members who all do the requisite certification. They all could have missed a hearing along the way. If they review the materials, do the certification, you can end up with a valid vote and a valid approval or denial in
Can
that
you miss the
situation.
first hearing as part of the Mullen, or must you attend the first
Yeah, I
hearing?
think you have to open with the quorum in the first hearing.
Yeah, but let's say you've got 4 out of 5. Can you Mullen in
Yes.
after that?
Yes.
You don't have
just
to be
can't-
there at the initial
right.
hearing
You can't Mullen in as a new member.
to kick somebody else
Right,
off.
right.
But if you only had 4 instead of 5 members,
Yes.
you can Mullen back in.
You're good.
Because somebody,
Yeah.
you didn't have to be at the first
But
hearing.
essentially, if they can't get a quorum, they have to withdraw, and then they resubmit, and then they
Yeah.
would request for us to waive the fee, and it would
Yes.
be reopened as a new business.
Unless we're talking about the rule of necessity, but that's an entirely different issue.
Yes.
And that never happens here.
Basically saying you can't waive the board anymore.
Correct.
Right.
That's what we were
That
getting
went
an opinion
away.
on.
All that discussion.
But let's,
Keep going.
we're gonna keep going through town council. Ex parte communications,
I think we dealt with that, didn't we?
we got an opinion on that.
Yeah, it was a very brief opinion, which basically means, yes, you can have them. Ex parte communications sounds a little fancy. I mean, basically what you're talking about there is somebody who has an application before you speaking to an individual member somewhere around town about their application. You're free to do it if you're not communicating with that person as a quorum of the board, and if you're not thwarting the open meeting law. In other words, you're talking outside the meeting with an applicant, and then you say it to another member on the commission outside the hearing, and they say it to another, then you're thwarting, you're having this rolling meeting. You can't do that. You can communicate individually with members of the public for or against an application. You can do it. What I would recommend, and I put this in my email to you, is that you try not to do it. As a practical matter, you have to have some rapport with the people that you live with. These are your friends and neighbors, so you're going to want to be able to talk to people as a matter of practicality. But if you're really getting into the substance of an application for or against, I would recommend strongly that take place in the public meetings. And that way you're not subject to any claims that you were biased for or against something, or somebody didn't get a chance to refute something that you may have heard, or what really the record is. So yes, you can do it. I would recommend, as a practical matter, trying to get detailed substantive discussions into the public hearing.
COA filings with the town clerk's office?
This has to do with filing the certificate of appropriateness with the town clerk. Apparently, this hasn't been done. It's mandatory under Section 11 of the Act, so you've just got to do it.
What do we do about all the ones that weren't done for maybe a year?
Get them in.
We got to file them after the fact now?
I would file them, yeah.
'Cause that
Otherwise,
hasn't been
you have a limbo appeal period. Basically, you haven't triggered the 10-day appeal period by not filing that. That's what triggers in under.
Just the certificate, not the plans.
Yeah, correct.
We've
The
actually
approval.
had appeals on things
Right.
that did not have the COAs filed.
Yep,
The minutes were filed.
Minutes were filed.
yes.
So what's the validity of the appeals that were taken to the Board of Selectmen and under those circumstances?
Just under your customary practice, you're not going to be able to invalidate those appeals because of your own procedural error. You know, they had to do that as a practical matter. It was better that they approached it that way rather than going forward with building something saying, oh, you didn't file it with the town clerk's office, therefore it never got, finalized. So just leave those alone and just make sure they get filed from now on.
And file the ones that
So-
weren't filed.
Yeah, I would file them.
So that's clear. That's administrative. Okay. 3 Martins Lane remand.
Not much to say about that. That is remanded to you.
Schedule a
There's a
hearing.
new date, and
I think that's next week,
Next
isn't it?
week? Okay.
Right now, it's scheduled for next Tuesday.
Okay.
I have a question on that.
Yeah, go ahead.
Just quickly. One of our members has filed a warrant article to shut down Martin's Lane and make it a pedestrian walkway. What bearing does that have on the driveway? My understanding from you guys several months ago that we could not eliminate the driveway by doing this without having to either pay for it or still allowing them to get to this driveway.
I'm not sure I understand the question, but only to the extent, the warrant article is not on the agenda for tonight, but to the extent that question relates to this, which is just my advice with how you handle the remand, you're under the obligation to grant a certificate of appropriateness in accordance with any of the designs previously submitted.
Right.
The applicant's attorney has agreed to continuances, so that's the realm that you're in right now. If he were to object to you continuing it anymore, you would have to have that remand hearing, or you'd be in contempt of the court's
Right.
order.
I'm just curious, you couldn't
So-
get into the warrant article discussion until we actually get into the review of the articles at
Yes,
another time?
that's right, that's not on for tonight.
Okay.
Well, it isn't.
And you can't,
Down here, to give, just quickly, we talked about this earlier, that he wasn't going to give his opinions about those warrant articles. They're on here for your information. If you have questions, we can provide them to George and he can get back to us at a later date.
and the town meeting warrant goes through town manager and there's another attorney who works on your warrant and handles your town meeting, so that's where that should take place.
Okay. Under.
Any more
sec-
questions on these?
Yeah, under Section A, are there any further questions?
I have two
Yes.
technical questions on the opinions. On the Mullen Rule, if you have a board that consists of 5 people and that goes 2 or 3 meetings, and then in the say the 3rd meeting, one of the sitting members is not there, can a associate member or another member who has been at the other meetings but not sat on that hearing then participate?
No, I would have everybody participate. I don't see how they could.
Well, there's more members than sit on a hearing.
Yeah.
They only have 5, but then, so the associate members generally don't sit, or maybe one of the full members will sit out and the associate will sit. But if you have 5 members sitting on a hearing and 2 other people just sitting there watching for that hearing, if they sit there and watch during all the process, can they then join the board later? Because that has happened, and I'm wondering, sometimes it's useful, sometimes it's...
Yeah, I would have to look at it. I'm
They
not,
follow along.
yeah, I would need to,
They haven't missed a meeting.
yeah. I
They're
don't-
alternates.
I don't feel great about members not actually participating in the hearing.
They get plans, they hear the whole presentation.
But they
This is the way it's been going on since they started the HDC.
It may be fine. I would need to look at how you have, I'm not quite sure I understand the context that this happens in.
Well, there are 7 people sitting there, 5 of them sit on it.
Yeah.
2 meetings in, could someone who has been sitting there but not participating?
Why don't we give him the
Yeah.
chance to
Yeah, that's-
understand it and
yeah.
give us his opinion later?
Yeah, later is fine.
Yeah.
Okay.
But it's an important technical question.
This is going to mess up the
Yes. I think
entire process. That's not how it works.
Sure, and then the.
Yeah, probably
Make
is
sure that the
fine, but I'm
practice has
not,
been okay.
I'm not prepared to give an opinion on that of some. Fair enough.
And then my second technical question is, your town council opinion says that the board, the HTC doesn't have the authority to do deed restrictions, which, we don't need to get into, but you have advised that they can have conditions on the certificate of appropriateness that would in some ways substitute for that, which is fine. But I just want to clarify, or would like you to clarify, do those conditions have to be related to the legal jurisdiction of the board?
Yep.
And what I mean is they essentially have to be related to exterior architectural features or visibility or some other jurisdictional legal issue, and could not be conditioned on preserving historic interior fabric or those kind of things. Is that correct?
Yeah, that's correct, but the way.
We don't do that. We
Right.
haven't done that.
Right, the way Mark is distinguishing it is, if you have something that may be denied by the commission, if they really do feel that the exterior architectural feature is inappropriate, but that there's a way of mitigating that through some type of screening, then as part of the give and take of the process, even though they don't have jurisdiction over requiring you to plant vegetation, if there's some fix for it to fix the alteration of the exterior architectural feature, then that's where this issue comes up.
Sure, if it goes towards the visibility or the
Right.
exterior architectural
Right.
features.
And the applicant can always say, no, we don't agree to that, and then they can rule on the exterior architectural features, and then the appeal can be whether that was arbitrary and capricious.
Okay, Michael?
I'm Michael May from the Nantucket Preservation Trust, and I know there's been a lot of discussion about process, the HTC process, and I wanted to let you know that the NPT is conducting a study reviewing best practices for historic preservation commissions throughout the state, and we're hoping that that study will be able to help you all if there is a review and changes in the whole process. And we're looking at the legislation and how it compares to other communities. Also, just the whole process, how other Massachusetts communities, historic districts, their whole review process, including using staff, and then also the appeal or the review process once a decision is made. So I just wanted to make sure you all knew that, and hopefully it can help you and the community.
Great, thank you. Keep us updated. Does anyone have any other questions on Section A? We're just going to take a 5-minute break, and then we'll reconvene with Section B. Part B, Town of Nantucket Business. Request for a historic structure determination regarding 2 South Water Street.
It's actually 20.
No, 20 South Water Street.
I'm here, but I wasn't quite sure what the issue is for us tonight.
Who's presenting this?
I can just mention that this issue came up at a CPC meeting about maybe a month and a half, almost 2 months ago.
Okay.
And 2 of your members sitting here tonight who are on the CPC requested that the town put in a request to the HTC for a determination as to whether or not 20 South Water Street, the old police station, is a historic structure. So we were told that it's been tabled at least once. And I don't even think we have a presentation of any kind today because it was a request that didn't really generate from us.
Okay, go ahead.
I'm the Board of Selectmen member of the CPC, so I can give you a little additional background.
Hey, Bobby,
Can you come
John
down here
can't
so
hear
we can
you.
hear you better?
Sorry. There was an application put forth to the CPC by town administration to request funds to renovate part of 20 South Water. As everyone knows, 20 South Water is the old police station. We're trying to figure out the best use for that building. We're trying to keep as many town offices as we can downtown, and we're trying to get a path as to where we go with that property. One of the things that came up with the CPC grant was that once we accept, if we were given any money and we accept it, then a restriction goes on that property. And it was brought up at that time of whether or not the building is even in fact
an historic building. It's listed as historically significant, I believe, Linda, is that?
No, contributing.
Contributing, excuse me, contributing. It was built as a garage, it was never built as anything else. To turn it into office spaces, which we deeply need downtown, would be difficult to do, and we now have the new FEMA flood maps that make the whole first floor basically uninhabitable because it is on a slab. We'd have to get somebody to raise the building or do something. So before we go and spend any more money or grant any money from the CPC, we were hoping to have some type of guidance from the HCC as to whether the building is, whether we have to save the building, whether we can demolish the building, so we know where we're going from here.
Do we have the survey form here?
Yeah, it's in one of the.
It's in the handout it's in the handout you have.
The handout you have.
The back.
Can I make a quick comment, just based on what Bob was saying? As far as the flood maps, from my understanding in past practice on these properties, these floodplain levels or historic buildings may qualify for exemptions. So it could work in your favor for historic buildings to be exempted from some of these floodplain levels. So
My understanding in a public building is not.
I feel like we've already seen plans for the renovation of this. Didn't we see something preliminary?
No, we saw,
a while ago, they were
we saw
pretty-
changes
Quite
to
a
a
while ago.
dormer or something in the back because of the computers.
But it didn't go to HTC.
Yeah.
Go ahead.
As a member of the CPC that brought this up about the contributing versus historically significant versus we want to demolish it and put a new addition on the town building, which makes the most sense economically. The CPC was concerned about granting funding for this, not knowing what direction they wanted to go, and they need some direction because they need to start planning whether they demolish it or whether they build a new addition on the town building. There were several buildings on that block. An old, beautiful Greek revival was torn down in the 60s to make way for the new town building. There were two other ancillary structures down on that lower part. They were torn down. This structure does appear on the 1938 aerial pretty much as we see it today, with all of those dormers. What the CPC heard was that the building is incredibly difficult to do for an adaptive reuse because of the concrete, the rebar, the cells, handicap accessibility, the floodplain, et cetera, et cetera, et cetera. It was, and we talked about it at CPC that it would make better sense from a CPC point of view for them to tear it down, not get any CPC funds because there's no longer a historical structure there or a contributing structure. And from a town financial perspective, it would be better to tear it down and put the addition on that they had planned many years ago to the backside of the building, as opposed to having to keep it and getting CPC funds to renovate a structure that was going to be very difficult and costly to renovate if it was going to work at all. So it was suggested that they come to the HDC to see, very much like we did with 50 Union Street, to see what the sense of the board was on keeping the building or letting it go. Because they can't take one step in either direction until the HDC sort of has a go at this. Is that pretty much it?
Yeah.
My feeling is that I don't think that the town of Nantucket should own any historic buildings because I don't think, frankly, that it's in a position to take care of them, or it's really a high priority. I think it's probably best left in private hands. That said, I think the building does contribute. It's listed as contributing. I would prefer to see it stay. My recommendation would be for the town to sell it or find some other way to dispose of it. But I think it's in the wrong hands right now. That's my thoughts.
Do you want to go ahead, comment?
I didn't agree with that necessarily, that it should be sold to a private entity who can't fix the building either for all of the same reasons, because of the type of construction of the building and everything that's been done on the interior with the concrete and the bar. because I didn't think the town should give up any part of that block. I think the town should maintain that block and build a town building that's going to keep offices in town, et cetera, et cetera. So obviously, we're not voting on an application, but I appreciate the town's position. And I don't think the building should be sold. I think the town should maintain that land. You have a comment?
I'm sorry, can I just
Go ahead.
clarify something? We went to the CPC because we were advised to submit an application for historic preservation funds. We did a lot of research, we put an application together. We fully believed the building was historic. We're not asking you to make it unhistoric. We were advised to come to your meeting so that you all would make a determination on that. So whether it's in the wrong hands or not is not, I don't think, is very relevant. We just know, now we've missed our window for CPC because all those recommendations are all done and can't be changed. So if the building is historic, we have another year, and obviously a lot of other discussions have started in any case about downtown offices, municipal space, things like that. So perhaps that's not that big of a deal, but we're just following up on what we were advised to do. We don't really have a position on whether or not the building is historic. Just want to make that clear.
You just want a clear determination from us.
That's what we were asked to.
And it was my understanding from that meeting that both of the CPC members that sit in the HGC were actually considering it not historic.
Well, contributing versus historically significant are two different categories of use. Contributing is over 50 years. Historically significant, does this building contribute significantly to the historic fabric of downtown? The setting, as town council talked about earlier. And there's a major difference between the two.
Madam Chair.
Let me just interject there, because I was there, and if I'm sounding different, I'm not. What I did say is that this board can make the determination that it is not contributing. That's what I said. I didn't say that, and I said that would be the place to come to first, to have that discussion, so.
I just want
to. Is it or isn't it, so we know which way to go.
Well, I want to clarify Ms. Williams' statement. There is a distinction between contributing and individually significant, but they're both considered historic buildings, and they're protected under the Building with Nantucket in Mind guidelines. So that's what you're here for. That's what they're asking for, just to make that determination.
Well, in my
Others
mind,
may want to speak, because we've.
let me say something. In my mind, if it's listed in contributing, then it's contributing, and we would treat it as such, but we would hear a proposal for what you want to do. And we would approve something.
We just want to know if we can use the CPC funds or not.
So you want to make a vote?
Why?
Fine.
Yes,
Make a finding.
I think so, but yes, we have to make a vote.
If they want to tear it down,
But this same
they can't
board
get
has
CPC funding.
taken contributing buildings and said that they're no longer contributing. It happened right down in Easton Street.
Well,
And-
I don't have anything in front of me.
Well,
I'm just going on someone telling me that it's listed as contributing. That's not in my packet.
It's over 50 years.
I
I'm
have
sorry.
had no review prior to this. Obviously, two members are on the CPC and have seen something, but normally when we make determinations on things, we actually have something in front of us.
Which he said.
Well, and this is something that we talked about earlier, that there's a, concern about talking about
It's
this
not
building
here.
specifically, although I think we've already jumped over that hurdle. But as this commission has reviewed before, and this applies to the building code and other issues when we're looking at historic buildings and how they're exempt or they're not exempt. We've talked about and agreed to that based on our Nantucket Architectural and Cultural Resource Surveys, however it's listed as non-contributing, contributing, or individually significant, if it falls into the two categories for historic buildings, that this board consider that to be a historic building unless they had received some evidence that that building no longer qualified and had changed since those surveys were done.
Exactly.
Okay.
That is my understanding. You would have to come and prove in some way that it's no longer contributing. Michael, did you have a
Yeah,
question?
I just wanted to point out, and I don't know if this would be a requirement of a CPC grant, but for a historic preservation easement, a property has to be certified by the Massachusetts Historical Commission. And currently, a building built in 1938 would not be certified for preservation easement.
It's 1929.
1929, or 1929, would not be considered certified until the Secretary of the Interior signs off on the National Historic Landmark application, which has been gone through committee but has not been signed by the Secretary of the Interior. So it's kind of a little technicality there, but I don't know if that's required if it's the town property or not. I just want to know.
But those, just to, also, but those standards, Michael, correct me if I'm wrong, is to, when they evaluate it, it's listed or eligible for listing, and that's what it would be. It would potentially fall in the category of eligible for listing.
Since
it is of that.
It would be eligible for listing,
but we do have to wait.
Yeah, we have to wait until that's.
John,
Yeah,
go ahead.
I have a comment. The fire station where it is now is a little history. There was a building on the other side of it, which was a town building, now used to be a big white building. The one in the back was a Sanford building, and the one where the visitor center is, used to be the Hosier House, the second oldest house on the island. And over the years, back in the 50s, they decided to make some changes, and that's when in 1964, they built that building. In 1929, they built the fire station. Now, whether it's contributing or not, as a fire station, it may be contributing. So I'd like to have time to look into a little more information on it myself. Thank you.
Can I just try to clarify? The CPC funds are for historic preservation of a structure, yes?
Right.
And our practice has always been that anything that's contributing is considered contributing until it's proven that it's not. So I think that it's pretty clear that it does qualify.
Okay,
not the point.
I mean, that's,
When we went into the CPC, Erica and me,
yes.
we never even discussed demolishing 20 South Water. That got brought up at the CPC by the HTC members.
But that's immaterial.
But I'm just saying.
It doesn't make any sense to me.
But it's immaterial. I think they need to, they're close to getting to a ruling or determination here, and I think that's what you want, isn't it?
Here's what I have a question on.
Go ahead.
What do we have to do to get it listed as non-contributing? What do we have to prove to you to say we can tear that building down?
Is that the direction that you want to go?
They
I
need
mean,
to
that's
know
it.
if we're going to allow that.
I think that's a different
Here's
discussion.
the problem. Here's the problem.
That's a
we have.
different.
That's
We
what we're
have
saying.
no space, no town-owned land in the core district except for that block. Everyone in this town wants to keep town offices downtown. We have a building there.
No,
that-
I don't disagree with you
So,
on these things.
yeah, I guess for me, I would like to tear the building down and start fresh.
Then
So-
make an application.
So how do we do that, though? What is the criteria to make that building non-listed? So I know if I think we have a shot at it. Because this is where it was brought up at the CPC meeting by the members at large, that building's really, why are you even bothering to fix it? So before we went through all the effort, which I shouldn't say that because a lot of effort was put into the application that we've already lost out on for this year, to try to at least start the fix-up process because the roof leaks and everything else. What is the requirements to delist that building? Is it, so I know, can you tell me? Or is there do I have to come in and get a 5-page form to figure that out?
No, I can't as one person tell, can you give us an
You have to
example?
make
Would
an
be
application,
helpful.
and you have to prove why it's not historic. I mean, we have information that says that it is. So you have to say, the building, I'll give you an example. You have to go back and say, sorry?
Go ahead.
You have to go and say, this building has been altered to the extent that it no longer would qualify. There are standards for that. So that's what you would have to do. Now, it has been altered to a certain extent, but I've toured the building too, and in my estimation, it would still qualify easily as a historic building. I don't think it's been altered to that extent. Now, that's my opinion, but you could prove it otherwise if you have some of that evidence.
Did you have a form that I can look at that tells me how to delist it? Is there
There's not a form.
there's no list? So it's just.
Not that I'm aware of.
Your interpretation versus my interpretation.
Well, it's the interpretation of the board. and Staff is the, can give advisement.
John? Barry?
Barry?
Yeah, so I think you're getting the gist of it. There's two different avenues under which the town building can be addressed. All right, is it historic or is it not historic? Really, it's the crux of the decision point that's sitting there. And part of that can even tie into CPC funding. That's why the town, these people, even on the CPC, we're coming before you to ask, is it or isn't it? And if you're not sure, what standards are you applying under which to do it? So we can say one way or another. I'm hearing opinions, but I'm not hearing the answer of it is or it isn't. And so this is where we're turning to you to say, okay, fine, if it is, under which standards are you doing that? If it isn't, then that tells us something different about how we again can proceed with doing the whole thing.
Go ahead.
So I think that's what we're looking for from you, is that final opinion that says what is it in that context.
Here's the issue.
Right now, there is an opinion.
It's over 50 years old. That automatically means it's contributing.
Okay.
Because it's over 50 years old, it's contributing. Historically significant is an entirely different issue. Would the HDC consider allowing the town, because of all the problems involved with this building, and try to utilize this building and not lose the control of the property, would the HDC allow that building to be removed and a new addition put on, or whatever they decide to do to the back of the original town building? Because there is a plan out there for that from several years ago. That's the issue. If the town feels financially that it wants to go the route, they want the option to go the route of demolishing it, they need to know before they start going down that road that that is a viable option. If the HDC as a whole decides that because it's over 50 years old and it has some historical significance to whatever, and when we make that finding, we will never let you tear it down. You'll have to deal with trying to rehab and reuse that building regardless of the problems. That's what they need to know. That's what the discussion was at the CPC. I don't know if you're going to get that feeling this evening. It doesn't sound like it, because only Kevin and I have seen the full packet, which was a very interesting packet, that maybe all of the board members should have been afforded a hard copy of that packet through the staff, rather than saying it's on a website. There we go. But I think perhaps the only way to really get any teeth into this is to make an absolute application to see if it will allow you to demolish it and give that historical information which you painstakingly put together. And go through the exercise of making an application to see if that's possible.
It sounds like there's time, if that's the, if you want a determination on whether it's historic, right now it's listed as historic. And that's your determination right there. If you want to make an application to have it listed as not being contributing, or to make an argument for demolition, we just need to see the whole file at another meeting. And we can, I mean, I am happy to move it on to a.
You said it's historic, so we know now
No.
we can't.
No, don't go there.
It is listed as a contributing structure on what we use as a basis. That does not mean that people don't come and make valid arguments for how something's been changed. I have not seen the whole history of this, but I am happy to look at this. I think that we should do it at a regular business meeting as a formal application.
Well, there was a house on
If
Easton
that's where you
Street
wanna go with
that, was contributing. I think it was 30 Easton, if I remember right. Is that the right address? Yeah. And there had been so much alteration to the original house that the applicant came in and said that we don't think it's any longer contributing. I still happen to have thought that it was, but the rest of the board, I can't remember what the exact vote was, but the majority said, well, this really isn't contributing because it's been changed so much. So that was delisted, and the house was moved. So that's anyway, just to.
Can I ask if town council has any comment?
Well, I was going to say that based on the information that you have tonight, which is just the survey form, the NACR survey form, and can you make a determination based on that information if new information comes forth, which you should have the opportunity as a board to then review any new information when an application is forthcoming, that you could make a ruling at that time with that new information. Would that be a process that would work?
Sure.
Do you have any suggestions?
It sounds like the town has a little bit of time because you're past this round or, yeah, so maybe notice it for an upcoming meeting and.
So you can make that determination tonight based on what you have, and then you can look at the full application when they make it or if they make it.
He's pushing.
I don't think that we need to make a formal vote because as of right now, what we base things on is listed as a contributing structure. I think that it's better for you to bring a proposal to demolish it if that's what you want to do and bring the evidence as to why that makes sense. And not have us take a formal vote tonight.
Madam Chair, I have a comment.
Yes.
Yeah. The statement that anything over 50 years is judged as historical. Well, it is not. The guidebook states that all structures, at the time they wrote the guidebook, that all structures should be harmonious to a period of 1850 or before. Over the years, things have changed up to the 1890s, 1900s, and after that, you can't go back 50 years and say that before that, that's 1955, say. There's nothing historical. The only time we ever changed architecture on the island here was after the Second World War. Down next to where the printing plant is, all them little houses in there was called the Veterans Housing. And they're all story and a half, and that's when they started the ranch-style house. That's a modern house. And since then, there have been ranch styles all over the island, which is very economical for people. It's a nice little house. But to say 50 years, we have been wrong. I've said it for the last 4 or 5 years to the members and the public. 50 years is not old enough. It should go back, 1945 or 47 or before, when they started the ranch style. That's when Nantucket really got out of the farm style houses and Victorians, whatever. So I just want to give that as information. Thank you.
I think that you're hearing that the board is open to hearing an argument, but we don't have the proper materials before us right now to really get into the discussion. Is the town willing to bring that application?
We'll discuss it. We'll have to discuss it as a board.
Okay.
Because then you're going to get a definitive answer.
Should we have provided you with more information?
Yes. Somebody should have.
What if we're never informed to do that?
I mean, if you wanted me to make a determination tonight, I don't feel properly informed as to what we were talking about. And I don't know where that falls, but.
Jack, one last point.
I'd go ahead and bring a formal application in.
I have one last point.
Erica,
I have one last point that I'm trying to make. A couple of years ago, they submitted an application to add an addition to it. And it didn't work out. The exterior architecture features of the addition were really appropriate. Some changes were made. If they can maintain the brick and add on to it, maybe I saw that plan. But if you come back to us, I'd like to see some idea of what you want to put there in place of it too also. That'll have to, might as well work the two together.
Well, we can't make them go forth with all the design work.
We can't go spend $100,000 on plans to draw a renovation to a building that we may want to demo. So what we're going to do is we're going to talk about it as a board, but I'm going to suggest to the board that we apply for a blank demolition permit. If you grant us that, then we'll come back to you with plans as to what can go on the block. But we're not just going to spend money for renovation plans.
No, I don't think that we would all be in agreement.
Bob, what I was referring to, not to get new plans, just draw something that was whatever. You everything you want to put there, the 4 outsides and sketch around the window here, door here, bring it in, and then we can elaborate on it, whether it is worthy to replace what was there. We have to know what's going to replace. Usually we don't before we let somebody demolish something.
Okay.
Thank you.
Thanks.
Town council needs to leave.
Yes, I think
Any other
that
questions?
if we have other questions from you, we'll make a list and have them sent to you.
I'm
Thank
coming
you
back
very
down
much.
reasonably soon. Thank you. Good night, thank you.
all too soon.
Thank you.
Madam Chair, we also have number 2. If no one's here for number 2, he's number 3 on the C3, Hummock Pond Homeowners Association, and he also has a vote to catch.
Okay.
If you want to entertain that.
We'll skip to number 3 because there's no one here to represent number 2.
I'm going to hand out, you have this in your packet, but these are better quality handouts. My name's Greg Ross, and I represent the Hummock Pond of Nantucket Homeowners Association, which is a cluster subdivision down off Hummock Pond Road. I'm here tonight to ask you to help us preserve the neighborhood. And I only want to talk about exterior design issues.
I think we've been there already.
You don't want to demo anything.
I don't want to demo anything. I want to do the opposite. I'd like to just walk you through this package. We'll go through it fairly quickly. I'm really here to talk about preserving some things that are in our subdivision and treating it as a common development, okay? The first page, this letter, is going to be what I'm going to talk about. The second page is just certification that our homeowners voted for me to come forward to talk to you about this. Starting with the presentation, I just want to communicate a little history and so forth of the area. The first page, it says Hummock Pond of Nantucket. Hummock Pond of Nantucket was a cluster subdivision of 36 homes. It was approved in 1981, and it's located off Hummock Pond Road. I think it was one of the first or second one of these that was done. Second one that knows the history. It includes the 4 roads: Ahab Drive, Queequeg Drive, Moby Wake, Melville Court, Ishmael Road. The lots are between 1/2 and 3/4 of an acre. Plus, we've got 56 acres of open space, and its underlying zoning is LUG2. There are no open lots, and we've got restrictions in terms of the coverage and so forth. There are no building height restrictions, though, except the town 30-foot limit, but there are currently no buildings that exceed 25 feet, and homes are serviced with private wells and septic systems, and half of them are within the zone of Hummock Pond watershed. The picture here, the aerial, except for the X, are the streets, and they come together as a common cluster, except the Ishmael Road sort of runs off by its own and may be considered, without thinking of this as one development, as separate. The homes, the characteristics, architecture was conceived and consistently applied as Nantucket cottage-style homes. The next few pages show you the original brochure for the architecture, which kind of gives you a feel for it, and you just sort of page through it with me. You'll see a series of small cottage, one-story homes. They all are cedar shingle roofs, cedar shingle siding, and they're all under 25 feet. That's been maintained over the years, the 30 years. People have added garage studios, but most of the houses have been expanded within the sort of framework. If you go toward the back of it, you'll see it's sort of the outline of the actual subdivision and how the homes are clustered together. The concerns that have raised in our area that started us to look at this is there's an advent of town water to come down in that area, and possibly sewers, which will permit large structures and impact the cottage-like environment we've enjoyed. The Board of Health has talked about dealing with it similar to what they did in Matticat when water came in there, but only about half our homes lie within the watershed where they could still protect things with a number of bedrooms. With no height restriction below 30 feet, large uncharacteristic homes on small lots could be built. And our other concern is that when the HDC does its comparable analysis, that you look at the homes belonging to our community and apply standards consistent within that subdivision, and not necessarily the homes that are around it in Cisco. So our request is fairly simple, is to treat the homes on those 4 roads as belonging to a common neighborhood with common architecture when reviewing building plans for consistency and compatibility, and that you adopt 3 specific standards that our homeowners have approved. To limit structure height to 25 feet, require cedar shingle unfinished for roofing material, and require white cedar shingles unfinished for siding, which is essentially will keep the characteristic of it. So we're looking for assistance and to be able to work with the HDC and to have those guidelines continue to the extent you can do that.
Question, Linda?
Up until what, earlier this year, what's his name had complete control over the architectural designs? What was it, Abramson? What is his name? The guy-
Gorondona. Yeah, there's a long, ugly history of the developer having control. The Homeowners Association really didn't get formal control of things until last October. Okay, so, but
Do you not have my question is, I know all designs, having worked on them for many years, I know most of the designs had to go to him in New York to be approved. Can the Homeowners Association, I've seen your documents, reconstitute yourself to have architectural review like Woodbury had it for a long time, 2 or 3 other places we've dealt with, you know, can you do that then?
Yes, here's the background. We have the restrictions, deed restrictions. People were supposed to go to him for approval. Some did, some didn't. He never enforced it because he was an absentee developer. The restrictions don't have these specific things in as restrictions, but they do have a plan review process that would allow the developer to decide what was appropriate. Those restrictions expire in April because they hit the 30-year limit. We initially weren't going to extend them. We feel that getting support, we've asked the planning board for some support on the 25-foot limit. And we
do an overlay.
Yeah, and we thought it would be much more effective if we could work with you on the same set of guidelines, okay, so that an applicant can come and there can be consistency. We weren't going to extend them, but now, just up recently, last couple of weeks, we've decided, well, as insurance, let's try to extend them. So we're in the process of trying to do that. It's a ugly process through the courts, and so we're starting.
But who would a group of homeowners
the board would be, you'd have to submit.
Architectural review?
Yeah, and it would be we would do it based on what was voted. See, these standards were voted by the homeowners, so that would be the applicant. But we would like to have it be to gain assistance with the HDC and be in sync with the HDC. So it's not just us.
Because we've dealt with these things before, and we're not bound by any of these, Woodbury or anybody else. We can, in my opinion, we can take them into account and certainly keep that in mind every time somebody comes in here, because as you know, other people have tried to go over 25 feet, particularly with garages and things like that.
Yeah.
I certainly am sensitive to what you want in there.
I'm just looking for what process or procedure would work. In other words, if you can just give us some guidelines. I noticed that you have advisory boards in other areas, and you identify, it seems like through your agenda, you identify when somebody comes in for an application that they're part of some area, because I see the color coding.
Old historic districts.
Yeah, well, Matticat's got in there, isn't some others? Anyway, we're just looking for. Wisconsin, yeah. So maybe there could be something where at least when somebody comes in, you're aware that it's part of our subdivision, and these are some things that we feel are consistent. You probably would feel are consistent as well, but.
I just don't know if we have any legal right to require any of these things.
Oh, really? I didn't know that.
Because we can't adopt them, because these area plans have their own things going on. They're not part of the HDC.
Is that accurate?
We've been asked this before, and we haven't. We could decide to depart, but we generally don't.
But this is a very, I was just going to say, this is a very specific subdivision with houses that look very similar, and I think we always take that into consideration and try and keep things in keeping with the context.
Yeah, I think one thing we wanted to communicate is that, especially with one of the roads, sort of as often a spur, that you at least identify that it's part of our subdivision and not the greater Cisco area. So when you make a determination that you're doing, that's one request. And then the other request is, if you looked around and looked at all the materials, you would see that these are the materials that have been used. Okay, so.
I think you have more teeth if you create your architectural review board. And we do know when one comes in here from Woodbury or someplace else that was approved or not approved. Tatimo have the same things, I think.
I don't think they have a review board, but they have specific
things in the
styles.
subdivision it's
And
supposed to
the
have.
same thing with
Yeah, right. Surfside.
Aurora Way
Yeah.
has a 23-foot height restriction, I believe.
Yeah, I mean, I think as far as us adopting separate rules, I think that would be outside of our framework because
Right.
we have those guidelines set up already. What I'm hearing, it seems to be what Ms. Williams is talking about as well, as far as being a homeowners association review board that would be separate from the HCC, but it doesn't mean you can't coordinate to a certain extent.
Right.
Yeah, and communicate things.
Tell us whether you approve it or not.
It's all about enforcement, so town council would have to look at that as well. But I think the most significant issue here, or example, is that take the roofs in your subdivision there, they're all wood except for one, which this board approved. So therefore, we have this thing going on already that, that although we're reviewing it on contextual issues, they may not agree with what the homeowners association is doing. So if they can agree to something and have some kind of document that they all have to buy into, then that would help bolster what you're doing. And then
Yeah, and then I think to have it be,
turn down a wood roof, but to deny an asphalt roof would be the question in this particular example.
The
So
height
it's
thing,
important
you
for
can-
us
you can control the
to
height through that
understand the
overlay.
list of things that,
yeah,
as an association, you generally,
that's all we've got, are those two, the only characteristics that I think we want to get involved in are the height.
but you won't get notice on those things is the problem,
Well,
unless it's a
Yeah, I'll give you an example. I mean,
addition.
Noshop has this going on right now, and they've become more active in their homeowners association, and so it has to come to them to get ratified, but they're two separate reviews. It comes to us, and it has to go to them, and you have to meet criteria for both. Sometimes we may be more restrictive, sometimes they may be more restrictive.
What we're trying to do is just communicate the things we're going to, so that the homeowner isn't in the middle, and to the extent, if you were to make a judgment on what's congruous with everything else, you would pick those restrictions, okay? So
Yeah,
it's
and
just,
that's where the coordination comes. I think
Yeah.
you're exactly right.
Right.
The service to homeowner, so that they don't get a differing viewpoint.
Right.
But we do have to look at the legal ramifications to see what we could imply there or not. But it would be a dominance of wood roofs, and you could say, well, look, they're all wood roofs. This needs to fit. But that's something town council could help you with.
Plus, when we get an application in here, in there in particular, we generally take a view. And if it doesn't look like it fits with those weird truncated roofs and all that other strange stuff going on in there, and there's a lot of transom windows and stuff. If it doesn't fit in with the architecture, it's not happening.
right. I think it just, in our case, it's just going to be the height. We'll leave the real aesthetic stuff to you guys, because we don't want to get into that. It's just, if you just look at what's the basic characteristic, they're not tall, they've all got wood roofs, they've all got
Lot of
cedar shingles.
one-story
A lot of one-story, and there's, 1.5 with the garage studio, so. I'm just looking for a way for us to connect.
Get your association
Well, we're moving,
together really
we're
quickly.
moving ahead with that, Linda. So we're looking for a way to make a connection.
Madam Chairperson?
You don't get notice for everything, but you can sign up to get the agendas emailed to you every week, and then you can look at the list.
Well, how does the
You
thing
can
work,
always
how does the
submit
thing
a
work
letter.
with the color coding?
Yeah, and
Could we be recognized as an advisory board and then,
Well,
so that you were aware?
Those are subcommittees of the HCC. You could request the HCC. That's something I was saying, that they need to check with town council to see
Okay.
how much it needs to be, whether it's that way, because the ones you're talking about, I don't know that it fits this criteria, because those are neighborhoods, they're not a subdivision. There's a bit of a distinction, because Sconset is an area, it has multiple neighborhoods. Mattocket is an area, it has multiple neighborhoods.
Okay.
And this is one neighborhood, so, and it's a homeowners association versus a neighborhood, and an advisory review area of that neighborhood or section.
And that's been an advisory generally for historic properties.
Certainly
For the
getting
most
the agendas emailed would be a good start.
Sconset, Mattocket, review both. So I don't know how much that would factor in, but
If I comment to the gentleman, it might be possible where if every lot in a subdivision is owned, has ownership,
Does.
that, and a 30-year restriction goes out, they can, I understand they can all sign an affidavit and renew it for another 30 years.
That's what we're trying to do. Okay, I was just looking for a way to connect the two processes so that it worked for
So I
everybody.
think if, I mean, we can look at this again, but he's going to have to go.
I think that we understand the
Okay.
gist of what you're looking for, but just my recommendation is to make sure that you get the agendas on a weekly basis, so that.
And then
Comment.
you'd receive could get a comment from us.
Absolutely.
That's what we
wanna know.
always
Okay.
get
If you
comments
guys
from
are okay
abutters.
with it.
Okay,
And that's
thank
always
you.
available.
All right, thank you very much for your time.
Thank you.
For coming.
Talk about them another time. Move on.
Do we want to talk about Leiden? Why, he's not here.
We just gotta make sure he comes at some point.
Did you want to talk about number 2?
What?
Roofing proposal?
No. Number 5. Go for it.
Okay, we'll save that. Number 4, that's a handout. Number 5, Mr. Cohen, would you like to speak?
I would. Can I sit here with that? Is that okay?
Yeah. Then you'll get picked up.
And stick to the points.
I will stick to the points. Thank you, Linda. So, my name is Stephen Cohen, and I represent the Citizens for Sensible Preservation, which is a group of people who are concerned with how the HDC operates and would like to see some improvements to that. I have submitted a letter to the Board of Selectmen asking for a review of the HDC process, and I also submitted a letter to the HDC suggesting that some of this stuff could be looked at internally. After I submitted my original letter, I submitted a second letter that tried to consolidate the 2 pages down to 1 page and try to organize those thoughts into process issues and legal issues. And I have 22 process issues and 23 legal issues. And, you know, after
Do you have copies of that?
it was provided to the chair and to the administrator. I do have copies.
It's not physically here.
Anytime that happens, Mr. White, I suggest you put it
I've
in
seen
the
it. I
packet.
don't have
I have some extra copies.
We don't always bring the copies, Mark.
So,
Madam Chair, may I interrupt for just a moment, and Mr. Cohen as well? If you'd like copies instead of berating me for something like that, I have some right here.
Well, I asked him, and he answered you didn't.
Well, why don't you give me enough time to give them to you?
So-
Okay? I don't appreciate it.
I don't either.
All right, stop.
let me just say that at the outset, I don't think that anybody is against the HDC or anybody wants to see there not be an HDC or anybody wants to see a weakened HDC. I think what a lot of people would like to see is a more efficient HDC that is operating within its jurisdiction and with a very efficient process. And to the extent this process determines that there can be, or a review determines that there could be improvements to the process or there could be improvements to the jurisdiction, I think that would go very well. You know, the gentleman, I think it's Mr. May, from the MPT suggested that they were doing that study. I think that sounds fantastic. I think that is exactly the kind of thing that we should be doing. And, you know, frankly, my clients and the Nantucket Preservation Trust aren't necessarily always on the same page, but I'm sure that they think that study would be a very contributing thing to get done. I'm not going to go through every single thing, but I'll summarize somewhat what's involved here. I think that if the HDC was willing to look at its process and think that some more of these items that are currently happening at the meetings could happen at the staff level or could happen under clearer standards and more defined guidelines and more defined regulations, that we would be able to avoid a lot of what we have now. What we have now is a process that takes months and can go through multiple meetings and is very unpredictable and very burdensome on the homeowners. And I think, frankly, it's going to be very burdensome on the members. The time commitment of being an HDC member, in my opinion, is going to be overwhelming. I'd like to see you guys spending your time on what's important and not on all the minutia. And a lot of times we spend a lot of time on stuff that could get taken care of at a staff level, or I think should be taken care of at a staff level. But some of that means sending more work and different kinds of work to the staff. And part of the process of the reorganization of the planning and land use department, hopefully, now that the HTC staff doesn't have to do the budget and the supervision and all the clerical stuff, hopefully they'll be able to do more professional services. But frankly, not only were they not empowered to do that, I've been at meetings where they've been yelled at for doing that. I've been here eight years and I've seen that happen multiple times. So hopefully that's something that will happen with the support of the board. But if we had more, better, clearer guidelines with a different process for how this was going to get done, I think we'd have a more successful HDC and a more successful product and a lot less animosity and a lot less burden. I'm looking at my list because I'm trying not to repeat a lot of things that we already covered before, and I'm trying not to read all 45 of them.
Thank you.
Why don't you go to the one that we all agree on, which is O?
Just on a very small thing that Linda mentioned, there's a change now that is a very recent change that all the historic areas are heard first at the meetings, and that's actually creates a very long meeting where all of the other people who happen to not be able to afford to live in a historic area are going last and are being continued over and over to these other meetings. That is something I think you guys could fix on your own really quickly, and just do the first come first serve like you were would be more fair and would not front load the meetings the way you have been. But basically, from beginning to end, from the way the applications are taken to the way they're considered to what level of review is done at the meetings, if you guys are willing to review the process, I think that the Planning and Land Use Department, and I hope the Board of Selectmen, would be willing to do that. And it could be a very cooperative effort so that, maybe in a year from now, we could have an HDC that is really efficient and really providing historic building protection to Nantucket's, aesthetic without all the problems that we have now. Now, aside from that process, there's also been, over time, a creep of your jurisdiction to things that, I don't think that the HDC has jurisdiction over. And since we already covered that a lot now, I'm not going to repeat them all, but I think the HDC, as part of this process, needs to scale back and stick to things that are within its jurisdiction, and also comply with laws like the open meeting law and the Mullen Rule and all these kind of things, which I think we're pretty well covered already. So hopefully the HDC will support a review by the Board of Selectmen that would set up a process that would do this. And the reason why I think the Board of Selectmen and the town need to be involved, as opposed to just the HDC internally, is that some of this stuff has to do with jurisdiction that might need to be improved, because clearly the HDC thinks or wants that it has authority that it may not have, and perhaps some of that would be appropriate to add. And we should get on that. But the HDC can't do that internally administratively. The HDC can't change staffing at the town level administratively. The HDC can't, there's a lot of things here that are just over the head and beyond the control of the HDC. And I think we need not only a comprehensive process for the legal and financial and budgetary reasons, but also something that is open and inclusive and transparent for the community. One of the reasons why people came to me as an attorney to help represent this group is frankly that a lot of people feel really intimidated and scared about voicing their concerns because they make their living in front of the HDC. And apparently I'm not as smart as they are, and I'm willing to sit at this table and voice those concerns. But there are a lot of people out there that are not willing or able to do that.
Are there any here tonight?
Yeah.
Or is this a secret?
Yeah.
We have no idea how many people you represent or who you represent. It's this nebulous group. I know a few, but it's this nebulous group.
Well,
and I don't want people to think that there are more people involved than there are.
It shouldn't matter. The issues with the HDC shouldn't matter how many people think there are issues. But I think if we had an open and transparent process, it would encourage people to come forward and say, these are the improvements that I think that could be made, and this is what I've seen. And we don't necessarily need to just have people come in and complain, but if we could have a constructive process, I think that would be helpful.
Well, you're not being open and transparent either, Steve.
Well, I don't know what I haven't put on the table, but this is what I think should happen. I think there should be a ground-up review of the HDC, and a lot of that can be done by the HDC internally, but it's going to need support from the town, because if you say, okay, we really want to send we want to have more done through consent, and we want to have more done through staff, and we want to, do those kinds of changes, then that needs support from the staffing level, that the people who are hired by the town to do those jobs are allowed to do that they're not just stuck with clerical work or whatever.
Can I just say something?
Sure.
Just frankly, Section D, which is all of the stuff that's been submitted by commissioners,
Yeah.
covers a number of things that are on your list.
Sure.
And actually, the original intention of this organizational meeting was to start this ground-up review.
Right.
And
So let us do
we
it.
don't have any time to do it tonight because I think that we're going to
We
have...
don't do it in
It's
secret.
8 o'clock. And we do it at a public meeting. And, one of the things that we've been trying to accomplish is to get a meeting with Leslie, with Andrew, with town council, and hammer out some of these issues, but we've gotten caught up in a lot of discussion about what's wrong tonight. We need to schedule another meeting to start talking about how to fix it. And I think that there's no one on this board that disagrees with that.
Right, and I think that's great, but when I submitted my list, that was not known to me, and in fact, I was criticized publicly in the newspaper by a member of this board for having the gall of suggesting that any of this stuff happened to the Board of Selectmen. I just think that the issue should be reviewed by the HDC, but it's also bigger than the HDC. You guys can't fix this on your own. And it should be more.
We can fix a
We're
lot of this
getting
on our
Right,
own.
the
and-
support.
Well, I'm willing to go sit down and
We
let
had
you.
town council here tonight.
Yeah.
We've had many people from the town here tonight to discuss some of the stuff.
Great.
So-
Well, I think getting that ball rolling is very important.
I
I'm glad
don't
to
know
see it
that we
happen.
need to turn it over to the Board of the Selectmen to, what are you looking for? Do you want the selectmen to establish another committee
They
to
can
help
tell us what
review
to do.
what we're doing? Or we need to go to them and ask for what we need as far as town council opinions?
Well, I think that's part of what was concerning to me, Steve, is that you just took your issues right to the selectmen. You didn't come to our board. Every week that we take comments in and we listen to people, and I think we are very transparent. There's no backroom deals that we're doing. So you took it right to the selectmen. The first time I heard about any of your issues was watching the selectmen's meeting, and I don't think that's right. I don't think that's being very cooperative.
I don't think it's being open and transparent either.
It's at the selectmen meeting, but I also submitted that same letter to the HDC administrator the next day. The reason why I think, I'm not saying that the selectmen need to be in charge of the HDC or be in charge of the process, but I think that there's essentially two issues. One is that several of the issues, including the budget and the legal stuff, are beyond your control. And the second thing is that it is very uncomfortable for people who make their living appearing before the board to come to the board and say, by the way, you guys are exceeding your authority and doing all this stuff wrong, and you should do it differently. And I think what we saw tonight was every time town council would say something like that, he got a lot of pushback. And he's town council. Can you imagine if it was some architect who's saying that?
Steve, I got to object, because there wasn't pushback.
It was clarification.
Clarification. I've been on here for over 15 years. John's been on here since Methuselah was here. And so we were presented, when we came on, with a certain way of doing things, with a certain way of understanding. And as you know full well, every time the composition of the board changed, opinions came in, because it is by nature and by law a subjective process. So somebody came in with ideas that some of us didn't agree with, but that's the way the board went, because the majority agreed with it. Then there was something else. Then there was something else. So every time there was a new chairman, things changed. Every time there was a new composition, things changed. We've gotten so far afield, in my opinion, that we really needed to have town council here. It's not a question of pushback. It's a question of there's a lot of new people on the board and they don't understand how we got to this point, and that maybe we shouldn't have gotten to that point. So we're trying to get clarification. We're trying to understand all the nuances of the legislation versus practice versus what's making all the designers uncomfortable. I could care less if a designer came in tonight and started screaming at us, because we need to be screamed at sometimes. We've got to fix some of this stuff. But going on and on and on and on, like you have, is not allowing us to get to D, where we can actually vote to put things back first come, first serve. We can actually vote to fix the process, and we've gotten nowhere on fixing that process tonight. We do have a better understanding of what we have jurisdiction over, but we've fixed no process tonight because we haven't been able to get there. We've spent 3 hours not getting to the most important part of this agenda. And everybody's got something to say about what we need to do to fix the process. You certainly do. But everybody in this room has a complaint about the process and what has happened, and we haven't been able to vote on anything or fix anything. And frankly, the first come, first served to me is the most irritating part of this whole process. But have we been able to get to it and vote? No. And that is very frustrating after 3 hours.
I look forward to working with the board on these issues in whatever forum appears for it. Thank you.
Sooner the
No,
better.
don't leave.
All right.
We're going to start talking about it. Ron?
Ron Winchurch. I just want to say that I believe that the articles that we talked about with town council, you were brought forth because of the start of our group. And I really think that, there's a lot of issues. This has been coming a long time. And I think that, you read these complaints, you already addressed them. The reason you addressed them is because everybody here wants to get this going. And so please don't be mad at us.
Let's do it
Don't be mad
then.
at us for bringing this forward. And the reason I started this group, and the reason I started this group is because they can't. They have to see you every day. I don't care. It has to be somebody that isn't in the design business that comes forward, and that's why I did.
No, it doesn't. They know what's wrong. They deal with it all the
can't-
time.
But they can't challenge you. I can.
Sure
But they all vote. Everybody votes.
I want them to challenge us. If we don't meet the public's need, and we're doing things that we shouldn't be doing, and the process is screwed up like it is, then I need to hear it from those guys. We need support from those guys to change the problems,
well,
okay?
we heard
And I don't
from
mind them
council.
coming to us and doing that.
Yeah, well, we heard from town council that indeed, you've been overstepping your jurisdiction. Until tonight, I had no idea that you didn't have the right to walk around the building. I mean, that was new to me. I've been here 25 years. And I said to Steve, does that mean that because they've been doing it for so many years, does that constitute law? He says, absolutely not. Well, I think you should be able to do that. And there's a lot of things that we would like to empower you with that you were stripped of tonight. And I think that this is what we need to work together towards, because we don't want to see the fabric of the building torn down if it's unnecessary. We want to, see reasonable consent by your board on reasonable requests.
All right, that's the bigger picture. We have process issues like this historic stuff up front, which exhausts us, and I hate this thing. We have certain process issues that are part of the smaller picture, not the bigger legislative issue, that we can solve by simply a vote of the members sitting here to put it back to what it was for 20 years, if not longer. First come, first serve. Spread them out. So it's not the same guys. We had one guy being shot off to Thursday and never got to on Thursday every single week. It's crazy.
Different people have their
The
hands.
thing is that, we've given this little outline here of things that we thought were easy fixes amongst yourselves. We think that this list is a very easy list that you can solve yourself. I think there's a lot more to be added to the list. And I think we'll be bringing that forward, and we will be transparent about it. And you're on notice that, we think there's other changes that need to happen besides this simple stuff.
But can you bring it to us?
No, we will. Yeah, but we want to be gather more information. We want to, be open to the public to comment. I think that the entire voting public in Nantucket may have a different opinion than the group that sits here.
Well, yeah, I think if we have a process that is a public process, that may be an HDC-sponsored process where the HDC is calling the meeting, but it's a public process, that's certainly different than, trying to do things through the public comment and before the meeting. I personally don't have any pride of ownership or commitment that it has to be one process and not another process. It just needs to happen. I think everyone can agree that the process is broken and needs to be fixed, not only because it's too hard and too difficult and too burdensome, it's too important.
So let us start.
Oh,
We
yeah.
spent 3.5 hours
I've
not
also
fixing
had-
anything.
Two at once?
I've also had discussion with David Barham, who's the normal chairman who's not here tonight, and he, I think, was on board with the idea of setting up some kind of a regular meeting to try and hammer out some of these issues, sponsored by us as the HDC, where we schedule the meeting and have continued organizational meetings.
We need to do it more than once a year. We just.
Maybe once a month?
I mean, you know, the applications are way up from where they were. I think that, I think that this reorganization has not really worked, you know, in my opinion. Staff is getting swamped with more work with less people. There's, and, you know, and that results in lots of these issues that just don't get resolved. And I think going forward, we have to look at the kind of support that they're, you know, that they're given, because that's what we have to work with.
John?
I have two comments. One, I think that constructive criticism is good to have. Doesn't hurt anybody if it helps you do a better job and serve the public. And the other one is that one thing that has been a slowdown is that in the wisdom of whoever's making all these changes in this town in the last year and a half, they took 2 people out of our office. The paperwork is time consumed. No matter what people say, you've got to get more people in the office to help out just HDC. That's what you need, at least 1, maybe 2. They hired a couple more people out last week, you know.
I mean, even in the old days, they were in one office space. Sorry.
You thought you were done.
Thought you were done, Johnny.
You think too much. But, you know, they're spending in one hand but not there, you know? And this got this town completely upside down. They now taking people downtown, move them out of town. They want the business, people want the people to come downtown and do business. You're not gonna go down to town building for one office there, one over there, and one over, 2 playgrounds. Doesn't make sense, but that's what's happening.
I think that that's one of the things that we wanted to discuss.
Right, you
But
spread it out
Andrew's
too
not
far.
here now.
Leslie's here.
Do you want
And
to
she's their direct
address
supervisor.
anything, or do you want to take that up at another time, the reorganization?
I'd just like to make one quick comment that, you know, we keep hearing that the HDC staff doesn't have any help. There are 5 clerical people in our office that can help them at any time. And the 5 clerical people seem to be able to help the other departments. So I think once they receive some training, which your HDC staff people have said that they will provide to them, hasn't happened, but it's going to, that will help. And I think when you all revise some of your processes, which you're talking about, that will help the situation as well. I mean, everything's still fairly new, everyone's still adjusting, it's only been a couple of months.
Mark?
Just to be clear though, Leslie, I mean, I think what John was saying is that you can do the math a lot of different ways, but when it comes down to it, those 5 clerical existed prior to the consolidation, and there were more than those 5 clerical. Just because it's been consolidated doesn't mean that we still have the same amount of staff. And even today with those 5 clerical, as hard as they work, and we appreciate every ounce that they do, as James and I tell them daily, it's not enough. I don't think that's a secret. I think it does impede the workflow. I know the town has a difficult position, and it's not easy for me to say that, but that's the truth. We could use more help, and it's a function of the budget. If we had the budget, I don't think there would be any question that would be one of the first places that you would hire. But it's not adequate right now because it's especially with the information we went through with today, with open meeting law changes and interpretations, and how we've got to post these different things. James and I spend an inordinate amount of time putting together agendas and hardly have enough time to review items for the consent agenda, which is very valuable for applicants to get their stuff through. So I don't know the last time I really spent a lot of time using my expertise reviewing an application, a building application for HDC. I spend most of my time trying to tell people that they're on this meeting at that time, and hopefully they'll be heard. So just for clarification purposes.
Yes.
You want to say something?
Just one comment.
Would you come down
Sorry.
front, please?
He can't
hear you.
Thank you.
And could you say your name again?
Mike Ward, Builders Association.
Just one thing, the Build Association back in the 25th of October did send a letter to HDC to start this process. So there was some transparency there on getting this process started. We never heard anything back. Sent it directly to David, and it was just shut down, stopped there, and so that's part of the process that we were trying to move forward as a group to talk, communicate, get this process going, and we never heard anything.
I don't think we've seen David back since.
Well, I was going to say, this has been waiting for David, this right here. It can't be on tonight, we can't pass it out.
From back in
because
October 20.
we don't know what to do with it. We're certainly not saying, we're not shutting anything
Well,
down.
he got it. He got the letter, because he...
I'm not, no, I've got a copy and went to David Barham, the chairman,
Yep.
and I think we're waiting to hear what to do with it. We're certainly not shutting it down, though, just so you know. I mean, it's, where do we go from here?
We
So
just didn't
we're-
receive any feedback, is what I wanted to say.
Yeah, I don't know what feedback to give you. That was my concern. So until we talk about it with the commission and get somewhere with it.
Thank you.
Linda?
I have seen it. I did see it.
It's not new.
There were a lot of issues with it that were inappropriate, in my opinion, but it starts a conversation, and with all due respect, David has been very ill since right after that time. That week, he began to get very ill. He is still very ill, so he's not going to respond to you on his own because that would be highly inappropriate. As I said, I've seen it, David's seen it. The rest of the board probably has not seen it. It has not been on the agenda to discuss as an item at an open meeting. We can't discuss it among ourselves. We can't even have the rolling meeting. So that's why there's been no discussion. It was not shut down. Only two of us have seen it, as I said, and he's been very ill and he's been to one meeting since then.
Understood. This was just in response to your saying that nobody's coming forward with these questions.
It's a little odd
And
that
it
it's
was an
not on the
entirely
agenda.
different issue
tonight.
than what Steve has given us.
I don't know why it's not on the agenda
I don't
tonight.
know what it is, but is it
Because they
something
haven't seen it.
It's an email. I can't even remember all the stuff that's on there. All I know is that we've been waiting to have the board discuss it, and we weren't sure whether it should go on tonight or be some other discussion, so I haven't really even talked about it then.
In all fairness, we wanted to address, the commission has concerns, a lot of which dovetail with this list that you gave
All right,
us, Steve.
let's stop
And we can't
talking
even get there.
about it? I'm not sure what's being referred to. Maybe it can be readdressed to the board as a whole or to me, and I'll be, until David's well, I'll apparently be working on setting the agendas with the staff. So,
Realistically, all the point I was just trying to make is people have come forward,
okay,
and the statement was that people haven't come forward. We have come forward.
okay. Well, I'll be interested to read it, and hopefully we can discuss it at a later date.
Can we get to any of this stuff? Wait, Steve, you need to stop for a minute.
I
The
think
commission needs to get to its own stuff.
I'm done.
I think it's also, you know, speaking for myself here, and I think I may be speaking for some others. We all have different mannerisms in how we approach things at the table. Linda gets very excited.
Passionate.
And we can call it passionate. But I know everybody's, trying their damnedest. It's not easy. And I appreciate everybody's input that they give. We don't always reach the same conclusion. Very often I'm on the outside of a lot of things. But I think we're overall pretty well balanced, and I think it's great to have the benefit of people that have been on the board for a long time. And, obviously some bad habits have creeped in, and I hope we can get through them.
All right, can you take some of these up? He's done.
We're going to move on to the
Great.
commission's list for a little bit of time, and we're going to reschedule another meeting.
Next Thursday?
Yes, John McLaughlin, do you want to say something about number 1?
You want to start with mine? Okay. All right, my comments, I will. I could be short and sweet.
Where'd you go?
Just hand them.
Yeah. Let's have those down. I need 2 more to make sure.
Eat off
John, you have to
Wait, one more. My comments and observations of the operation of the procedures at our meetings. My comments are that I've noticed that a lot of times, and I feel this way, meetings should be run by a strong chairperson. There should be a civil attitude at all times to the public. There should be no interruptions allowed when someone is speaking. Everyone get their chance to speak. First to be staff comments. Second, commissioners' comments. Third, the applicants as to what was said by the members. Response to the commission comment. Fourth, call for the motion. Fifth, call for votes. But I think that the fact that we get so many, what eats up our time is comments back and forth. If a commission member says something, a designer or architect wants to argue one-on-one, let them make their comments of what we heard us say, and then come back to us and save a lot of time. The chairperson votes last, as according to parliamentary procedure, and I asked the public, I put things up on the wall, do not be repetitious, be brief, speak only on issues pertaining to the application. We all have copies. I just ask that we look for doing something about that in the future.
John,
Thank you.
I think that we all agree with that point of not having the back and forth that it eats up time. But, I mean, you are missing in here
That's the first
letting the applicant present their application.
yeah.
And public comment.
Yeah. Along with it, I have
Which we usually have in there,
one
but-
other comment that pertains basically to our operation. And this here, in 1993, April 27th, the existing board at that time met and made, the town council has been at us for years. All we have is a guidebook, which is a guideline. He said, start making rules and regulations. We set down rules and regulations on that date and voted it unanimously. And it's self-explanatory for the old historic areas of Sconset and town. In other words, your roof styles, dormers, skylights, scuttles, leaders, foundations, roof color. This pertains to what the town council said tonight, the exterior architectural features of the structure. And this is the answer. I would like us to tighten up in the old HTC area when applications come in, because this refers right back to early times. Thank you.
Okay, thank you, John.
Okay.
Kevin, did you want to talk about enforcement? I know that we've definitely touched on some stuff tonight.
Well,
But
I think that should be held for
do you
town
want to
council.
hold that over?
I do want to hold it over, but I'd like to bend Leslie's ear just a little bit on this, because my understanding is that we don't get to enforcement because we don't have the staffing. And I'm also, sit on a sign advisory committee, and I know between myself and my fellow members on that committee, we have sent in dozens, if not hundreds, of signage violations on the island over the past 3 years. This past year and a half, we have not had any response on those violations. It's not fair to other businesses that are going by the rules. They pop up all the time, and people, submit them in with photographs and dates, and the story usually is, it was for a while, well, we can't get to that because we're in transition, we're moving, we're going to get more help, and here we are, and there hasn't been, we went through a whole summer season with a lot of violations that, in my opinion, I think, slowly chip away at what we're presenting to the public and the public that comes here. That same thing happens with violations on building sites. There are arbors, there are gates, there are things that are part of the architecture of the outside and of the streetscape that are popping up left and right. Photographs, again, are sent into the staff, they're documented, and there's no time for follow-up. I think there could be, if we were not to start building any new structures, there'd be enough violation cleanup on this island to keep everybody busy for a long time. And I think it's fair to the people that do go through the process and that do go by the rules that everybody should be held to that standard. And without enforcement, does it make any sense to go in through any of these rules at all? And I'm really pleading with you to find a way that we can get enforcement, from our board through our staff to, do the right things for the community. And, we can talk more about it later, but I really wanted that to be heard because, you know, frankly, there hasn't been anybody from Plus at any of our meetings that I've attended, and I don't think I've missed a one. Maybe one, I was out sick. But these are important things, and, you know, we pass it on to staff, they're aware of it, and it stops. So anyway, you know, it's an important issue for me. It's the only one that I put on the agenda, in hopes that we can at least get one thing accomplished. So that's my comments. Thank you, Madam Chair.
Linda?
It is rather frustrating because we've been through it with the planning board decisions. We've been through it with the ZBA decisions that when I was with the ZBA, we were told that because of money or whatever, we just don't do enforcement. So it was kind of, which is why we created the zoning enforcement officer many years ago, is because we were getting no enforcement. So we were doing all this work, spending all the time that the HDC spends, and no board spends as much time doing their business as the HDC does, just by operation of the way it was created. And we're getting frustrated that there isn't an ability to have an enforcement officer for the HDC because there are violations everywhere. And we heard how town council wants us to handle them. But you can't do the applications even with 5 staff members helping and still have enforcement, because that's an entirely different issue. So I do think that the administration, Andrew, yourself, the board should come up with a system for doing violations, because we just don't have the time. But why are we sitting here doing these COAs if they're not going to be enforced? So unless Mark gets to the end when he's doing the inspections to sign off on the building card, it's a little late then sometimes. So we've got to come up with something. We just can't keep letting it go on and on and on and on and on, because there's stuff everywhere. We see it all the time.
Leslie?
We are in the process of reevaluating job descriptions. We are in the process of coming up with ways to make everyone really, but specific to this discussion, inspections, enforcement better. And we're looking at ways to spread that around to different staff people so it's not all consolidated in one area. And an example of that is we've had the local building inspector performing some of the inspections for HDC, not the difficult detail-oriented ones, but some easy ones that he can do while he's at the job site anyway. So that's taken some of the responsibility off of James and Mark as far as having to leave the office and go out, drive around, they have more time in the office. And we're looking at efficiencies like that I hope will help with some of the concerns that you all have.
Enforcement's a big issue.
There should be some follow-through when...
Went through the proper way to proceed with enforcement tonight. I think that's a positive step in the right direction, to at least know how to proceed moving forward.
Okay. Barry?
Madam Chairperson, if I may, through you to Leslie. Leslie, when did Plus come into effect?
Everyone moved into the building on, I think, July 16th.
Okay.
And then it was official in August.
Okay. I think I hear what the board's saying about certain enforcement issues and stuff, but I think we need to be a little clear too. Just as one member of the public, I'm hearing you heap about 3 years worth of potential ills and lack of remedy to things just within the short period of time under which you've got a new administrative staff to start looking at these things. And I know there's been a lot of processes that still need to take place. So I think respectfully, you need to kind of learn to separate those as well too, and realize that you've got a relatively new staff, new administration, trying to handle multiple issues at the same time. But I'm also hearing from them as well too, they're looking for the appropriate guidance under which to do it. I mean, it's a big laundry list to try to tackle. So it's just, all I'm saying to you is, it's one thing I'm hearing sitting here as a member of the public, and I'm a little concerned about that direction.
Yeah, that's true, and I think that's a fair comment. And I was hoping Libby would have been here actually, because she has been around through all of it. And it's very difficult for any organization, let alone one that's all volunteer. But the HDC has been under 3 different directors, basically, within 3 years. It's been under Libby. It went, to Ray, and he didn't want it, and now it's under Andrew. So those kinds of things cause things sometimes not to happen. So yes, it isn't all Leslie, but I hope the word gets back that there are those of us out there that have been taking pictures and sending in violations for 3 years, and we're wondering, I get people on my sign committee saying, should we just abandon this because nothing's being done? And you have to give them an answer. So thank you for that, though.
Well, so I think you're hearing a concern. Ron?
Don't you think that the building inspector could handle a lot more of the inspections for the HDC? I think, you know, the entire organization down there seems to be working together, the building department, the HDC, and Alan's there for every final inspection. Why can't, he's a builder, Steve, they have great experience, they can look at plans and take care of those inspections when they're doing the final.
It sounds as though they have been doing some of them.
I know they have been doing some, but I mean, why can't that, you know, to take the responsibility? I know Mark is really backed up, you know, trying to, if you go and look at the book, you know, he's weeks behind. You know, why can't it be just handled with one person?
I believe there's a 2-week, isn't that what we're trying to do, is a 2-week turnaround, Leslie?
Correction, last week it was 0 weeks.
It's gotten better, right?
Last week, we were at 0. This is
All right.
the correction. It's been that way. We went from 6 weeks in July.
Well, I'm just saying that
That's an
might be
update.
an option, you know, just make it part of their purview and be done with it.
Okay. Steve?
Steve Rocky, Mark.
Can you come down front, please? I can hear you better. Thank you.
Congrats on a long climb back on that inspection list. Kudos. I might just offer that on a couple of occasions I've been able to accomplish an HDC final inspection with photographs of something that's simple, concise, easy to do, and I just wonder if that isn't I'm not sure if that's a policy or if it's just a practice, but it seems to me an opportunity to streamline the amount of running around that Mark or James may have to do in appropriate cases. And perhaps we'd have to identify what those kind of particulars are. I'm not proposing that we might sign off on an entire house in the historic core. But as you well know, there are plenty of applications that apply to very minor changes. And those of us that practice before this board certainly have a reputation that we're interested in protecting. We're not going to try to, you know, shoot ourselves in the foot by not being forthright with the photos that we could easily provide you. And also, there's plenty of builders that are tied to projects with their licenses and their reputations as well. So I think they also really want to do the right thing. I think all of us do. And so I do wonder if there's an opportunity for us to help a little bit with the load. We all have phones, most of us, cameras, computers, color printers, email. It's very simple for us to file. If that's something the board would consider, I think there's plenty of us that would be happy to do it.
Can I just ask a procedural, should the board really be discussing how inspections and things function within the office? Or should we be focusing more on how we function in meetings, as far as what we need to discuss, as opposed to what people can make suggestions to you about as far as procedures within the office?
How they fix it is their business.
Well, that's what.
But we have a concern that there is a problem.
I think it's good for the board and the staff to hear what the concerns are, but I think the procedural aspects of inspections, filing applications, that type of thing is administrative. I think it should be left to the administration to figure out.
It is helpful for the positive and negative feedback. I think that's what works and what doesn't.
I just don't know that that's something that we should actually be taking any kind of a vote on.
No.
I don't think we're voting on anything.
It's just, I think you got to be aware of it.
I do want to try to wrap up a couple of things tonight that maybe we should be voting on as far as how we function at meetings. If that's okay.
There's anything in the crowd.
Is there anyone who is here that really wanted to speak about something specific?
I have some things here.
Okay, I know, we're getting to you.
But I think they're going to deal with what they have a problem
All right.
with. I think I've already covered, a lot of my things are covering their things.
Okay, these are some things that, we're getting into some things that we do at meetings that Linda wanted to address. Do you want to take the floor?
Some of these I think we've already covered, but I know when we get a project, Ron's project at 4 Monomoy is a good example where there are multiple structures. We have a tendency to look at the main house and not at the garage, not at the pool house, not at the hardscaping, not any of the rest of it. So when we finally worked through a main house after 2 or 3 months, we got to start all over on the garage, the pool, the hardscaping, and the studio. Is it more helpful for you guys to remember to ask us at the table to look at all the stuff that night and not hold the other 4 or 5 applications and wait for the main house? I know some of this stuff we're going to carry over, but do you want us to look at the whole project so you can start working on the other things, right?
Matt?
Quickly on that point, I mean, I think that the history of that is, if there are details of the main house that you're gonna ask us to change, like rafter tails, window types.
Trim.
6/6 to 2/2s. Often there was a history of saying, well, why don't we hold off on the garage until you get some clarification on those window types, then you can subsequently change those details. But I think there are certain situations where the applicant would prefer to see some of those other structures, and I said, if you just, you know, if the application does request to look at those other structures at that first meeting, then you allow us to do that.
So I think it would speed up the process instead of expanding the process where you have to look at every single thing by themselves after we're done with the main house. That puts you like another month behind.
Ron?
I just want to speak on the 4 months.
Let's try to keep it
I did speak to Mark prior to the application going to the board. I requested on behalf of the architect flying over from the vineyard that we be allowed to present the entire package to the board on the first night. Mark said that was okay. In his idea, it was okay. I went to the meeting, I spoke to Mark before the meeting, and he said, well, it's really up to the board. And I said, well, I just had 3 architects fly over here for this meeting, and we don't want it to be just rubber stamped into hold for viewing. We wanted to present the project, which we kind of begrudgingly got you to do. I think it was totally a waste of time because at that point, we did not actually, you know, accomplish anything. It was held for viewing 4 times. That project was held for viewing 4 times. And, you know, it was staffing problems, and I totally agree and feel sorry for you all. But, you know, that request was made. We need to have, like, if an application goes into the board, it should be automatically sent to you guys that if you want to go to a viewing before it's there for the first time, let's cut this meeting loss for every architect and everybody that comes in there. I mean, it's an automatic rubber stamp by you guys, and that needs to stop.
Okay.
I understand. Can I comment that?
Yeah,
Yeah, there has been a lot of talk about, because since you've all gone digital, that it would be simple to email out the digital file that you send into staff so we get to see them, because people assume we see these before the meetings, like the HCC and like the planning board and the ZBA. We don't. But these files can be very huge, and frankly, I don't have enough memory in my computer to take them all, but there are some big projects that are multi-structured. Maybe we can come up with something as we work through all these things to have those sent to us by email, since they have the digital copies, and then we can see these things ahead of time, obviously not discuss them, but it may cut down on having to say view after you get everybody over here. But I'm more concerned right now about not looking at the whole project in every building so we can make suggestions on every building when we just have to start that all over again after we finish 3 months working on the house. That's what concerns me.
That's exactly it. And the other issue was whether or not, you know, you should be saying that you can demo. It's like what was going on here with the town building here. They don't want to spend the money to bring to you a proposal if they haven't established whether we can have a demo. A demo should be issued the first night, and you know, you're going to work out the details. Obviously, the client wants to build a house. They're going to come back to you. So if they propose to you and it's a demo on the first meeting, on the first night, if there's no objection, it should be granted.
The only time it's come up that's been a concern, I know that more recently we have said, let's just vote on it, because we don't mind if it ends up being a vacant lot. There have been a couple of occasions where something in town we don't want the lot to be vacant.
I can understand.
So we do hold those for that reason, but we try to give the applicant clear direction, or I believe that we do, as to whether it's going to be allowed or not, as far as going forth with reviewing a new design.
I think what Bob was trying to get from you guys is
but-
he come to you with a demo application.
And we told him to just go ahead and come in.
Right.
I think that's a good move.
Matt?
Just a really quick suggestion about the views. Is it possible to potentially create an automatic view list in the same way that there's a consent list? Again, it puts a little burden on the staff. But again, if the agenda is released and there was an automatic view list, that might be helpful for people who don't have to spend the whole night there. Because usually around 7 o'clock, you guys will start to create, you'll actually make an announcement of things that are on automatic view.
So something where the staff go through
And the chairman.
Before the meeting, yes, putting more burden
check
on
things
staff.
off ahead of time?
And just for the record too, I wanted to say that before the reorganization, I think the discussion with the staff, I think that the staff has been in flux and they actually, they've lost 50% of their staff. And I understand that the reorganization, the intent is to have more people help out with some of those other tasks. But just as somebody who's been, been part of the process pretty regularly, I think that the staff needs more help. I think that they're definitely would notice from a user perspective that, and you're going to get to this, but through staff approvals, which were traditionally could go on the next day after the meeting, 1 or 2 days, you get the through staff approval. It's actually quicker now to wait the 2 weeks, make the changes, and just get it through the meeting, just so there's no question. So, whether or not, I'm sure there's ways to fix it, but I would just say from a user perspective, I think the staff seems more burdened, if you will say.
I think, Leslie, didn't you put a timeline on approvals through staff when they had to get out?
We talked about one, I believe it was, I can't remember off the top of my head, I'll have to get back to it.
It wasn't a month
Well,
or
I think
6
they're on
weeks.
if I can answer, I think they're on a more regularized basis. I don't think after the move, there's obviously some glitches and, you've got different hands and eyes looking at stuff. And that's one of the things that just takes time for that staff to get used to. They never did any HTC stuff. It's a whole new world to them. And we're relying on them to help us out. So they're trying their best, and, we've got to, it's just hard for us to even get training. Like you said, we want to train them, but on-the-job training is a lot different than taking somebody aside and then doing it. But, we're open to all these things, but it is a function. There are choices, there are limits to what we can do. We've tried, I have to give James a lot of credit because there are things that we were forced to do, going to electronic submission. I know it's some ways maybe it's a pain to some people, but we wouldn't be able to do a lot of things we are still doing if we hadn't changed by losing some people in the office and going to PDFs being submitted and so forth. We get so many requests, as this gentleman was here tonight from the Hummock Pond. I get requests daily, multiples of what's going on in the properties next to me, and there's no way we could continue to do what we were doing before by going back and getting these plans and people stopping in the office and us trying to hand them these plans and try to cooperate or coordinate all this stuff. So there's been some real efficiencies, and I'm hopeful that our e-permitting stuff that looks very promising will finally, it'll probably have some rough edges, but I think that'll go a long way and will help with the shorter staff that we have, because everybody there is busy, and I just don't know how they do anymore. It's a choice of, when we got caught up in HCC stuff in the last couple of weeks in a few areas, then the building stuff starts to get a little bit behind, so it shifts.
I just, in defense of the staff on the through approvals through staff, sometimes they go very quickly, but I've had at least 2 of my clients had it held up because there was 1 or 2 HBC members who sort of took control over it and told the administrator, I don't want you signing off on this until I sign off on it, and then that got held up for 4 or 5 or 6 weeks.
Months.
Yeah, so the board members need to stop doing that too.
Yes.
It's I think inappropriate, but also the point of staff approval is to avoid having to wait. So if you're giving it to staff, I think they should be empowered to do it.
Well, to be fair, those arrangements would be made at the meeting. I don't think we've ever done anything where a staff member is going to say this can't be done. If it was a condition of the approval and that needs to be met, I mean, then we still make that a condition and make sure that it's done, but.
Yeah, but
I get,
the
the
approval
point is
not
to get them done
through
sooner.
staff on the consent of the board member who's really interested in it. That's not what's been approved.
And that's
but
not
what
appropriate.
happens
But
sometimes.
that's-
And you're right, it's not appropriate.
You're right, that wouldn't be appropriate.
We're
That's what's
hearing your,
happened.
hearing your point. Steve?
Just a quick follow-up on the view comment, if I could. I kind of like Matt's idea about a view list, but it seems to me that it should be at the request of the applicant. On these multi-application projects, many of us in this room spend hundreds of hours working on the overall composition across the site. And there are times where we actually do want to come in and talk to you, make a presentation about the project at large before you go out to do a view, because I believe that I know more about the project at that moment than you do, and I want to share that. I want to help you understand the context, the strategies behind the design. And so the automatic view list is interesting, but there will be projects that I've done that I wouldn't necessarily want to go to automatic view. I want the opportunity to come in, make my presentation to you all, help you understand the issues that I've identified, and then invite you to go do a view so that I can have your feedback, having seen the site within the context of the
Right.
mindset that we've.
Okay. Well, we're not going to vote on anything in regard to that tonight.
Let me just run through these. We've already dealt with my next one, which is preservation versus historic review. We're dealing with the timeline on approvals through staff release. We're already dealing with that. Training of support staff under a plus program intake process, which has to happen. I guess it was scheduled and then it didn't happen. Handling of submissions to the HCC. I know personally that people have emailed into this email address and the plans were not pulled off and brought to the meeting. For safety's sake, everybody bring a copy of what they send in, because many times we've gotten there and the file's been lost, or there's a piece not in the file, or it was sent into that email address and it was never pulled off and put in the file. I'm not going to get into it with you. And I think what you, my word of caution with you guys is to make sure that you bring copies of everything you submit, because you guys show up at the meeting with no
Okay,
copies.
Okay, Linda.
All right, restitution.
Wait, Mark
I'm not
wants
getting
to
into it.
say, let him, you have to let him speak.
I'm not sure what you're referring to, because we don't utilize the electronic submission for the drawings at the meeting. So if I encourage them, as you said, for people to bring a backup copy just in case.
Yeah.
But it's really been more of a function of new people handling new functions in the office more than anything else.
Well, I'm concerned that people have emailed stuff in that where they were told to email it and not pulled off that site.
We don't
Leave
pull
it there.
anything off that site for the meetings.
Well, then why do they email in?
For record-keeping purposes, we email it to people that are interested.
You do both, is that?
Well, that was not clear to them.
We don't print, we don't have the capacity to print plans that you review at the meeting, so I don't know I don't know where you're getting your information.
Well, they felt that they had to send it in that way because they obviously didn't get a clear idea of what they were supposed to do. Reinstitution of the design, reinstitution of the Design Advisory Committee would help a lot of these people that are doing designs on their own. That went the way of the wind several years ago, so that's something we can talk about another time. How to speed up the meetings, I'm sure you guys have a lot of opinions about that. Automatic views, I think we just talked about. Incomplete applications, guys. When we sit down at the table, nobody's able to jettison a plan, an application, before it gets to us at the table, and we get it at the table, and it's incomplete. So I don't know how to solve that at the ZBA level and the planning board level. They're not put on the agenda if they come in incomplete. We're getting them all incomplete anyway. So I think you guys got to be a little bit more careful about that, but I also like to come up with something administratively where they don't even hit the agenda if they're not complete. But we don't have time to, apparently, with the staff, review them all to make sure they're complete, and the staff, the support staff hasn't been trained in order to do that. Board representation on advisory committees, we need to get there.
Can I just say that I totally agree with you, and I know on the advisory committee, that's one of our biggest frustrations about that these things are complete. I think 90% of the applications are, but it's that 10% really slow down the whole process.
And we're volunteering our time, and we need to get things organized so that we can function at meetings in a more reasonable way. And I mean, we cannot continue to do 4 hours every Tuesday, to do 2 or 3 hours every Thursday,
And viewings.
and to do all of our viewings. We need things to run more smoothly.
Board
Mark-
representation, want to keep going with this?
Let
one?
me take
Oh,
this.
I'm still on this
John.
one.
Tony got the BBC. I can't take credit, but David Barnwell, I think 6 months ago, more back, that what we're hearing obviously is we're short-staffed, you need more staff. There's no funds for that. Application fees. We're fortunate we do some other projects in other communities. The filing fees are in the thousands in some of these communities. We submitted applications there, it's $5,000, not $500 or $10 million, $1 million, $6 million. And my clients never even questioned, never blinked. And if there's any way that can be reevaluated so that that provides maybe funds for additional staffing, that will improve the process overall, it's something maybe worth at least considering and looking at.
If the town had staff advisory time, they could charge hourly for that time. Or they could set up a system to charge for that time that would generate revenue to pay for that time. And, you know, if people are paying their architect to redesign a house 8 times, I'm sure they'd rather pay to have it done through staff and save 6 meetings, if that would work, something like that.
Okay.
The next one is, board representation. Guys, rope it in. Board representation on advisory committees. I know I've had a lot of complaints that there's more than one member of the HDC on some of these advisory committees. I think we need to deal with that internally, because I'm not in favor of that. Access to town council, we can deal with internally. I'm going to go back up to how to speed up the meetings. This goes, it's not really phrased the way I had it, but it was putting all the old historic stuff up first. That's something I'd like to deal with tonight. I don't agree that we should put all the old historic stuff up first. Where I'm exhausted by the end of it, it doesn't move the meeting along. There's no break in between these things. Frankly, we're not a preservation board. We're not there to do that. They're no more important to somebody than their first house on Hooper Farm Road or something else. I think it's unfair. We operated perfectly before with first come, first serve. I think we need to go back to first come, first serve, which worked fine before, and not the same person gets bumped every single time. And I know every one of you in here supports that. I've had nothing but complaints about it. And I, Madam Chairman, would like to make a motion to put it back to first come, first serve.
I think we should have some discussion.
We need to discuss.
This is not working.
Hold on. John?
No, I have a comment, and I'd like to send it out to the designers and architects that come to the meeting. A lot of times, there are a few that come in, very few, but they do.
John, is this on the topic we're discussing?
No, I'm sorry, I thought
Can we
you
go
should-
to that next?
No,
Because I want to
I'll
take
make-
comments
close the
on,
comment.
Do they want to comment on that?
on this because she wants to make a motion. Kevin, do you want to have a discussion?
I totally understand Linda's point on this. However, I feel that where the board, given the amount of time we have and the amount of energy that we have going into a 4 or 5 hour meeting, that I think it's best focused on our oldest buildings in our core of our town. And yes, they do take longer up front. I think people, with technology, get informed as to when there are, items coming up on the agenda. And I see where when the non-historic, areas come up later, those, tend to go faster, and they should go faster. But I think if it is kept, at the front, I found that it has worked well. There's been people from the community that can come because they tend to be more interested in the old historic cores than other areas. And I don't see where it hasn't worked, and I'm not in favor of, moving it quite so quickly. I don't think we've been doing it all that long, and we have so far one member who's been vocally against it, so.
Go for it.
Steve?
In my experience, first come, first served has worked for as long as I've been practicing here. I think as a group of architects and designers, we all understand that part of getting the commission while they're fresh is to know that you got to get in early on the agenda. And that's literally was kind of put on to us, and we all operated within that sort of reality. The way that the guidelines are written, the statutes, the entire island is a historic district. Now, I don't debate that some of our most important historic treasures are probably right here in town or in the core of Wisconsin. But the fact of the matter is we represent all applicants and they have their own projects and their projects are just as important to them whether they're out in Matacasham or right here in town. And so I think that the way it's always worked, first come, first serve, is fair. It's fair to every applicant. Putting the oldest ones first tends to sort of pick select projects and suggest that they're more important. Maybe they are, but that's not the way your guidelines are written. So maybe if it's really important to organize these things first, you need to take a broader look at the guidelines to understand how to deal with some of the outlying areas that maybe shouldn't be there in the first place.
Did anyone else? Stephen?
Yeah. There's just no justification, I think. It's just totally unfair to people who have less money and can't afford to live in some historic district, and now they have to go at the end of the meeting. I don't see the justification at all. You should spend all the time you want on important projects, but they shouldn't get to go first just because they're old. It's just not fair. The fair is first come, first served.
I open the door for Johnny every night because he's a little bit older than me.
People live in the OAC.
Doug Mills, I just wanted to add that viewings, if I understand correctly, also go on the front of the agenda, which I think is also unfair. Again, we had a project recently that it was put off because you couldn't get to it in time on a Tuesday. It was sent to Thursday. There was only 3 members, or I think there was only 2 members. It got put off to the following Tuesday. And then, again, because of other things jumping ahead of it that are brand new, by the way, you have things that are brand new, have never been heard by the board, jumping ahead of things that have been passed over twice, and then, so you don't get to it on that Tuesday, then go to Thursday again, only 2 members. It gets put off and put off and put off. Now you're 8 meetings deep and you haven't even heard comments yet, so it's just...
Go ahead, but I want to say something.
I just, as someone interested in historic properties, obviously I'd love them grouped together, but I think maybe the solution might be not necessarily always having them first. I think somebody who lives on Fair Street, for example, if they want to come to a meeting and there are 3 buildings on Fair Street and they're spread out over several hours, you're going to get less public participation. So it's really nice to group things together by neighborhoods, but it doesn't necessarily mean that you always have to have it first. So I think maybe there's some other way to look at it and consider it.
Can I say something before I understand why this was first instituted, and I thought it was a good idea because we do get tired by the end of the meetings, but I've seen in process that the same people do keep getting put off, partly because we're not finishing our meetings. And I think that in practice it hasn't worked out. I think that there's might be room to have separated on the new business agenda only, and then on old business, it's first come, first serve. That might be a compromise between the two opinions here. I'd like to hear from the staff.
Well,
You file your architects in?
since I've been here, I think this has been a work in progress, and it's always going to be. We arrived at this particular position because the other rendition didn't work very well. The commission has said, "Oh, we're tired. We got these things at the end of the agenda," and the very first rule was first come, first serve. And then that rule has been modified and modified and modified to tweak it, to make it try to work a little bit better. Somebody wins, sort of, somebody sort of loses, and I don't know which one's the fairest anymore, because the only fair thing would be to say first come, first serve. But things will still get carried over. Things will still not have quorums if we have the volume that we have. So it is a dilemma, and it's a double-edged sword, but it's up to the commission. I think the feedback is helpful, and they can switch back and we'll continue to try these different avenues.
Doug?
I want to say, in terms of projects that are in the core district that are going to attract the attention of a wide range of people from the neighborhood or from the wider community.
No one.
You know, we've had instances with the grocery store where there was a special item on the agenda at the beginning so that, you know, if there were people from the community that wanted to make comments, it was on the agenda, they knew exactly where it was at the beginning. I think that works. I don't think all of the old historic district projects need to be at the beginning. I mean, there are projects or properties in the old historic district that are not that special. I mean, it's just...
Well, how would the attorney who's here to help us, how would you pick and choose and make it fair? That's the dilemma.
Well, again, it goes back, in my mind, it goes back to projects that are going to be, you know, affecting the entire community.
The shipyard was an example.
And the yacht club on the waterfront, you know, the police station, I think will generate a lot of public interest. So, I mean, things like that.
I think the community requests and the board responds and sets something special as needed. And it is subjective.
There are other commissions that just take them first come, first served, but then when you have a project that turns out to be controversial and turns out to have people, you know, a lot of it, then they start putting it in the beginning. But not everything from every area needs to be put in the beginning. You guys can exercise a little discretion here, and I think that, you know, Linda's idea, I think it was of having them all in the beginning of just the first meeting, or was it Don's idea? But, you know, there's lots of ways to do it, but it should make sense and it should be fair. And right now, I'm not sure it is.
Well, why don't we leave things as they are for the rest of the year? We have to reschedule another meeting. John's leaving. It's after 9 o'clock. I mean, I think that this is really important, and I think that we do need to address it. But I think that we have to set a date for our next meeting, and I'm hoping that it can be sometime early in January.
I don't think we can afford to wait on this issue.
We're only talking about one more agenda. John McLaughlin wants to say something before the end. Rick, I'm sorry I didn't get to you.
Yes, I have to go. I have one closing comment, and it's what I see as a member, as the designers and architects that come in, is I find a lot of times, a couple of them, all right? Most of them are pretty quick, but that's what eats up our time, is if they're too repetitive when they speak. They repeat something over and over and over. If it's got to be carried to another meeting, they repeat it again. You know, and I think that it wastes too much of our time repeating stuff like that. I just say, don't beat it to death, and then there are other people waiting behind you. You know, you get yours, you go out the door, you know, but I say, I like to request them be a little quicker when they make a presentation. Thank you.
I could say the same thing, the commission could do the same also. They could say, I agree with John, I don't need to make a comment on that.
That doesn't happen all the time.
Before everybody starts to get up, we want to set another meeting to continue this discussion.
Could you want to do it tonight, or
You want to do it now?
Because you also want to, well, so you want to take...
I'd like to tentatively continue this organizational
Go
meeting.
next Thursday?
No, till January 10th.
Okay.
Okay, the 17th? January 7th, we're looking at January 17th.
Can we afford to wait that long?
Well, it feels like a long time, but it's because of the holidays. Our first meeting in January is the 8th, is our first Tuesday meeting. Kevin will be gone on the 10th, so we're talking about the 17th. I'd just like to give people some idea. We may change it, but I think that we're looking...
We don't have to wait for the organizational meeting, Linda, to address some of these things either.
Well, I want that on the agenda next week.
We can put it on there.
Well, you set the
Before you
agenda.
conclude, I'd like to just thank you. I think this was a really good meeting.
We'd like to thank the Dreamland Association for letting us have it here, and our TV
Thank
crew,
all of you for coming.
and everyone for
Happy
coming and
holidays.
participating.
Motion to adjourn.
Will, can we put in an item on the agenda next week to officially set our next organizational meeting? Okay.
No.
Well, I want it on the agenda.
Speak about...
Is there a motion to adjourn or
Can we just put it on the agenda?
When we can finish the audio, is there a motion to adjourn?
I make a motion to adjourn. All in favor?
All those in favor? Meeting
Yes,
adjourned.
it
Thank you.
does have to be on the agenda.